We'll request you all to take your seats. Good afternoon, ladies and gentlemen. May I please request you all to take your seats as we are starting shortly. Good afternoon, ladies and gentlemen. A very warm welcome to the first edition of the Indo-French Legal and Business Conference here in the beautiful Maison de Barreau de Paris. My name is Rishika Roy, and I will be your master of ceremony for this prestigious program this afternoon. We are delighted to see such a distinguished gathering from the judicial, legal, policy, and business communities of India and France. To formally commence today's conference, it is my honor to invite our dignitaries on stage. Justice Surya Kant, Honorable Chief Justice of India. His Excellency Sanjeev Singla, Ambassador of India to France and Monaco, and Ms. Carine Denoit-Benteux, Vice President, Paris Bar Association on stage. Along with Mr. Winsor Vigneault. Thank you. And before we start with the speeches, I would also like to invite Ms. Payal Kanwar on stage for a group photo as Madam Carine had to leave a little early. Thank you.
Monsieur le Président de la Cour suprême indienne, Monsieur l'ambassadeur de l'Inde en France, Monsieur le Président de la Chambre commerciale, financière et économique de la Cour de cassation, chères consoeurs et chers confrères indiens et français, Mesdames et Messieurs représentants d'entreprises, et puis Mesdames et Messieurs les étudiants. En l'absence du bâtonnier Louis de Gausse, qui malheureusement est retenu auprès du garde des Sceaux, j'ai l'immense plaisir de vous accueillir aujourd'hui pour ouvrir cet après-midi de conférence. Je m'en réjouis. Tout d'abord, je tiens à adresser mes plus sincères remerciements à tous les intervenants, et en particulier à l'honorable Surya Kant, Chief Justice of India, qui nous fait l'immense honneur de sa présence aujourd'hui. Je remercie également Madame la Vice-Bâtonnière Vanessa Bouzardeau, qui est à l'origine de ce beau rassemblement. Et Vanessa, tu nous diras un mot de la genèse de ce projet. Dans le contexte actuel d'instabilité mondiale et de tentation de repli sur soi, il nous faut plus que jamais dialoguer, échanger, nous rencontrer, entre avocats, mais aussi avec le secteur des affaires. Il nous faut construire plus de ponts entre confrères, professions et nations. Je salue la présidence de la Bar Association of India, M. Prashant Kumar, et je le remercie de permettre aussi ce pont. Dans ce contexte, nous avons besoin d'un état de droit fort, respecté. Un état de droit qui permette d'assurer la stabilité d'une société et de rassurer toutes celles et ceux qui en font partie. Un état de droit qui garantisse le respect des libertés publiques et individuelles. Nous l'avons dit lors de notre prise de fonction avec le bâtonnier, il y a une urgence démocratique, mais également une urgence économique, parce que les deux sont intimement liés. Un état de droit respecté génère, par sa prévisibilité, par sa constance, un climat favorable au développement économique et commercial et à l'innovation. L'état de droit, c'est un enjeu d'attractivité majeur et le Barreau de Paris entend bien jouer pleinement son rôle pour le défendre et le promouvoir. Nous savons que le plus grand pays au monde, l'Inde, partage cette même conviction. L'Inde, qui est depuis plusieurs années un allié stratégique et un partenaire économique majeur pour la France et l'Union européenne. L'accord de libre-échange signé ce mardi est une nouvelle preuve de vitalité et de densité de nos relations bilatérales. Cet accord invite à l'optimisme quant à l'avenir de la coopération et au développement de partenariats dans des secteurs toujours plus innovants. C'est précisément ce dynamisme que nous souhaitons célébrer aujourd'hui à travers ce forum franco-indien de droit et des affaires. C'est aussi une opportunité que nous souhaitons offrir aux avocats du Barreau de Paris de découvrir de nouveaux horizons, de nouvelles perspectives. Certains d'entre vous connaissent déjà très bien le marché indien, d'autres moins. Permettre la rencontre de nos consoeurs et confrères avec le secteur des affaires est vital. Et je tiens à remercier ici notre partenaire, la Chambre de commerce et d'industrie franco-indienne, qui a œuvré à nos côtés à l'organisation de cette journée. Cette journée vous offrira des regards croisés entre avocats et représentants d'entreprises, entre l'Inde et la France, sur des sujets aussi stratégiques que l'environnement douanier, les enjeux juridiques et l'intelligence artificielle, ou encore les projets de réforme de l'arbitrage dans chacun de nos pays. Je suis très fière de ce premier forum et encore plus fière de débuter mon mandat de vice-bâtonnière avec ces échanges de haut niveau. Je vous remercie et je vous souhaite des débats passionnants et une journée placée sous le signe du dialogue, de l'ouverture et de la coopération.
Thank you, Madam, for welcoming us for this landmark engagement. I now invite Ms. Payal Eskanver, Director General of the Indo-French Chamber of Commerce and Industry, to deliver the introductory address and share the vision behind the conference. Could we please have a round of applause?
Thank you very much, Rishika. Honorable Chief Justice of India, Justice Surya Kant, Your Excellency Ambassador of India to France and Monaco, Mr. Sanjeev Singla, Monsieur le Président de la Chambre commerciale, financière et économique de la Cour de cassation, Monsieur Vincent Vigneault, Madame la Vice-Bâtonnière du Barreau de Paris, chère Carine, distinguished guests, dear colleagues, ladies and gentlemen, I'll start with a few words in French. C'est un immense honneur pour nous à la CCI France-Inde, l'Indo-French Chamber of Commerce and Industry, de co-organiser cet événement d'exception qui réunit pour la toute première fois les communautés juridiques et économiques de la France et de l'Inde autour d'un même dialogue structuré. Cet événement est à la fois inédit et fondateur. Il marque une étape importante dans la manière dont nos deux écosystèmes peuvent désormais réfléchir ensemble aux grands enjeux transfrontaliers. Je souhaite tout d'abord remercier chaleureusement le Barreau de Paris pour son accueil, sa confiance et cette collaboration remarquable. Cette initiative est véritablement sans précédent et nous sommes très fiers de l'avoir construite ensemble. It was in September 2025 when we first met the Barreau de Paris in our office in Delhi, and we immediately had a connection where we decided that it would be a good idea to bring the legal and business ecosystems together. I'm very pleased and honored to welcome all of you today to the Indo-French Legal and Business Conference, organized under the aegis of the IFCI General Council and Corporate Affairs Committee, which is one of the 17 committees that we run at IFCI. This committee brings together legal heads and general counsels of our member companies, and I'm particularly happy to see so many members of this committee with us today. We have a delegation of 40 legal professionals who have traveled with us from India for the program today and tomorrow. We're deeply honored to hold this inaugural edition in the presence of our chief guest, the 53rd Honorable Chief Justice of India, Justice Surya Kant, the highest ranking authority of the Indian judiciary, and we are grateful for your presence, which gives us confidence, which gives this conference a truly historic dimension. Allow me to briefly introduce IFCI, which is today one of the most active bilateral chambers of commerce in India. We represent a team of 40 people in 6 offices and a network of over 800 member companies. This conference is by far one of our largest that we have ever organized in Paris. We also extend our gratitude, of course, to the Indian Embassy in Paris and the Cour de cassation for their invaluable support. Looking ahead, IFCI will also play an active role in the Indo-French Year of Innovation. The upcoming AI Summit in February in India will be a major milestone for this bilateral partnership. Today's topics are extremely relevant in the current geopolitical context, especially in light of the recent conclusion of the India-EU FTA, a historic milestone that I was personally honored to witness in Delhi on Tuesday. The free trade agreement also aims to strengthen cross-border trade and investment between India and the European Union, and of course France, which naturally implies an increased need for legal services and cross-border legal cooperation between our two jurisdictions. Before concluding, I would like to warmly thank our event partners, Denton's Link Legal, France Asia Foundation, Tri-Legal, Vishwanathan & Co., and our media partner, The Bar Bulletin. I wish you all a very inspiring and enriching afternoon of discussions, and I hope this conference will mark the beginning of a long and fruitful partnership. Thank you very much.
Thank you so much, Payal. And may I now request Mr. Siddharth Batra, Advocate on Record, Supreme Court of India, for a short address. Can we please have a round of applause for Mr. Batra?
Good afternoon. Bon après-midi à tous. It's a privilege for me to be standing here today before this august bar. It's not just personal, it's a professional honor as well to be standing here in this beautiful city of Paris, which stood always for its enduring civil values and the revolutionary legal thoughts. We have all gathered here today because the judicial head of my country, the Honorable Chief Justice of India, my Lord Justice Surya Kant, is here among us. He's not just a name on the bench. He's in fact a legacy which I have myself personally witnessed for the last 20 years. My Lords became the Advocate General of a state in India at the age of 37. All his predecessors, maybe were 20 years older than him. If I have to tell you in French, Advocate General would be the Procureur General, which is a constitutional post. At the young age of 41, my lords became a judge of the Punjab and Haryana High Court and continued from then for the last 24 years and now in the office of the Honorable Chief Justice. In fact, the judgments which have been passed by my lords are the judgments which have reached the common man of our country. The judgments are not just based upon law. The judgments are on substantial justice which has been delivered. My lords has been consistent in his approach. And in fact, it's a truly great occasion, an honor to see him in Paris today, being welcomed by the Paris Bar Association. Today, as we all have gathered here for the first inaugural, and what I got to know lately is that my lords is the first one in the last 15 years to come to Paris. Of course, the language remains a barrier, but since my lords arrived today in the morning, it's brought sunlight to Paris. I've been here since last Wednesday, and of course, we have a big trade agreement which has been signed. Of course, trade goes side by side, and legal has to start as well. I believe this conference would lay the stone for having a great legal partnership between both the countries together. And to the Vice President, in fact, I was just reading, and I must support the resolution which has been passed by the Paris Bar Association supporting the defense of lawyers, the client-attorney privilege. In fact, across jurisdictions, whenever a client-attorney privilege is attacked, that's an attack on the independence of our profession, that's an attack on the rule of law. So I completely support the resolution. And lastly, we begin a great journey today, and thank you all very much. Merci beaucoup.
Thank you, Mr. Batra. It is now my privilege to invite our special guest, His Excellency Mr. Sanjeev Singla, Ambassador of India to France and Monaco, to deliver the special address. Please welcome him with a huge round of applause.
Thank you. Thank you so much. Honorable Chief Justice of India, Justice Surya Kant, Mr. Vincent Vigneault, President, Commercial, Financial and Economic Chamber, Cour de Cassation, distinguished members of the French and Indian Judiciary, Ms. Carine Denoit-Benteux, Vice President, Paris Bar Association, members of the legal and business communities, ladies and gentlemen, bonjour, namaste. It's a great pleasure for me to join all of you today to this Indo-French Legal and Business Conference. I thank the Indo-French Chamber of Commerce and Industry and the Paris Bar Association for bringing together such a distinguished gathering at the confluence of law, business, and international cooperation. I'm especially delighted to welcome the Chief Justice, the Honorable Chief Justice of India, and I think his presence here today reflects the importance India places on judicial dialogue and on strengthening institutional linkages with France. Since his arrival early hours of the morning, he had very productive meetings with the presidents of Conseil Constitutionnel and Conseil d'État. And I also extend my appreciation to Mr. Vincent Vigneault, President of the Cour de Cassation, for joining us in this important exchange. Now, India and France share a trusted strategic partnership, which is built on shared democratic values and a strong commitment to the rule of law. Over years, our relationship has evolved into a comprehensive strategic partnership encompassing traditional areas like defense, nuclear, space, and now expanding into other areas like technology, education, environment, trade, and investment. And at the heart of this expanding engagement lies, of course, the legal framework which enables confidence, stability, and long-term cooperation. India has undertaken significant legal reforms in recent years to strengthen commercial certainty and investor confidence, especially in the area of modernization of dispute resolution and arbitration, simplification of corporate and labor regulation, digital governance, and ease of doing business. Collectively, these reforms underscore our commitment to a transparent, predictable, and globally aligned legal environment. France, with its strong legal institutions, rich jurisprudence, is a natural and valued partner in this journey. French companies have shown increasing confidence in the Indian market, reflected in their sustained and expanding presence across areas such as infrastructure, aeronautics, energy, manufacturing, finance, and technology. Many of these engagements are long-term, involving not only capital investment, but also operational commitment and technology transfer. At the same time, Indian companies are progressively expanding their footprint both in France and across Europe. Together, these trends point to a more mature, two-way economic relationship with a view to long-term partnerships. And this conference is therefore both timely and important, as India and the European Union have just concluded the free trade agreement, which has been referred to by my predecessors. Platforms such as this acquire added relevance. I would particularly highlight the role of legal professionals as key enablers of India-French partnership. Lawyers, judges, arbitrators, all of them help translate economic intent into a workable reality. Strong professional linkages between our legal and business communities will further enhance trust and support in this growing complexity of India-French partnership. So I wish the conference every success, and I look forward to valuable insights from today's deliberations. Thank you. Merci. Merci beaucoup. Dhanyavad. Thank you.
Thank you, Your Excellency, for your thoughtful address. May I now invite our special guest, Mr. Vincent Vigneault, President, Commercial, Financial and Economic Chamber of the Cour de Cassation, for the special address with a round of applause.
Dear Chief Justice, Monsieur l'Ambassadeur, Your Excellency, Mesdames les Vice-Bâtonnières, ladies and gentlemen, chers amis, today is a great day for our relationship between our two countries. This first meeting, business and law, is one more stone on the bridge between our two nations. Le commerce repose sur une double exigence, la prévisibilité de la règle et l'effectivité de la sanction. Sans prévisibilité, l'échange devient spéculation. Sans sanction effective, la règle devient une fiction. Cette ambition suppose des systèmes juridiques coopératifs, capables de reconnaître leurs décisions respectives, l'une et l'autre, et impose aux juges une posture ouverte, comprendre l'autre système, non pour le juger, mais pour en apprécier la logique, la cohérence, la légitimité. L'Inde et la France incarnent deux grandes traditions juridiques distinctes. L'une s'inscrit dans le common law, où le précédent construit progressivement la règle. L'autre relève du droit civil, où la loi codifiée structure l'ordre juridique. Ces différences ne constituent pas des obstacles, loin de là. J'y vois plutôt une source d'enrichissement par le dialogue entre ces deux systèmes. Ces différences, nos systèmes convergent vers l'essentiel, l'état de droit, l'indépendance du juge, la protection des droits, la sécurité des transactions. Trois questions structureront nos échanges aujourd'hui. L'environnement douanier et réglementaire, les défis posés par l'intelligence artificielle et la place de l'arbitrage. Trois questions qui révèlent une même réalité. Le juge français, comme le juge indien, ne travaille plus dans un espace clos. Il évolue dans un environnement mondialisé qui impose l'ouverture, la coopération, l'intelligence des systèmes étrangers. Le contentieux commercial confronte quotidiennement nos tribunaux à des situations où la loi applicable n'est pas française, où l'exécution d'un jugement étranger s'impose, où la validité d'une sentence arbitrale doit être appréciée. Cette internationalisation reflète la nature même du commerce international. En dehors de tout territoire, difficile à dire même en français, fluide, réfractaire aux cloisonnements nationaux. La Chambre commerciale de la Cour de cassation a pleinement intégré cette dimension. Sa jurisprudence recherche en permanence l'équilibre entre la protection des intérêts légitimes, la fluidité des échanges et la sécurité juridique. Elle présente 3 caractéristiques majeures. Elle est lisible, stable et prévisible. Cette prévisibilité constitue un enjeu d'attractivité fondamental. Paris, vous le savez, attire de nombreux sièges sociaux, des centres de décision, les opérations complexes, parce que le droit français offre cette sécurité. La France est la première destination européenne des investisseurs étrangers pour la 6e année consécutive, avec plus de 1 600 000 projets d'investissement en 2024. Sur ces 3 questions que vous avez décidé de fixer à l'ordre du jour, mesdames les vice-bâtonnières, mesdames, messieurs, permettez-moi quelques observations. Les tensions géopolitiques, les politiques de relocalisation, les impératifs environnementaux redessinent les flux commerciaux. L'Union européenne offre aux opérateurs étrangers un marché de 19 milliards d'euros, fondé sur une union douanière, un tarif extérieur commun et des normes stables et équitables, stable and fair, dont l'application est contrôlée par des juges indépendants et impartiaux. Deuxième observation, l'intelligence artificielle. Elle bouleverse tous les secteurs et soulève des questions juridiques majeures, en particulier la protection des données personnelles et la propriété industrielle. Si les législations indiennes et européennes présentent des différences, elles partagent assurément une même préoccupation: protéger les individus contre les usages abusifs de leurs données. Cette convergence permet le dialogue, la reconnaissance des standards et l'harmonisation progressive. L'arbitrage international, enfin. Il répond à 3 attentes des opérateurs: la confidentialité, la rapidité, la neutralité. La France a fait de l'arbitrage une priorité. En 2024, elle était la 2e destination mondiale. La Chambre de commerce internationale, dont le siège est à Paris, administre plus de 800 nouveaux arbitrages chaque année. L'Inde, je le sais, partage cette ambition. Mumbai, Delhi, Bangalore émergent comme des places d'arbitrage de référence. Des avocats français interviennent dans des arbitrages indiens siègent à Paris. Des arbitres indiens siègent à Paris. Cette circulation des compétences enrichit les pratiques, confronte les cultures juridiques et forge progressivement un langage commun. Ce premier forum, témoigne d'une conviction. Le droit des affaires se construit par le dialogue et non l'isolement. Les défis que nous affrontons, nous trouverons leur solution que si les juristes indiens et français que nous sommes acceptent de confronter leurs expériences, de partager leurs interrogations et de chercher ensemble les réponses adaptées. Le juge français est prêt à ce dialogue. French judge is open to this conversation. Sa jurisprudence le démontre. Sa pratique quotidienne l'impose. Le commerce ignorant les frontières, le droit doit apprendre à les franchir sans les nier. Les tables rondes qui suivront permettront d'approfondir, j'en suis certain, ces questions. Cette diversité des regards garantit la richesse du débat, permet d'identifier des situations pragmatiques et de construire des ponts entre nos 2 systèmes, to build bridges between our 2 nations. Je vous remercie de votre attention.
Thank you, Mr. Vigneault. Ladies and gentlemen, we now move on to a very special moment of the afternoon, the felicitation ceremony of our chief guest, Honorable Chief Justice of India, Justice Surya Kant. I now have the honor to invite Ms. Vanessa Busado, former Vice President of the Paris Bar, also to join us on stage, along with Mr. Akshay Jaitley, founding partner, Trilegal, who will deliver the felicitation address for Honorable Chief Justice of India. Could we please have you on stage, Vanessa and Akshay? And can we please have a round of applause? Barry?
For once, it wasn't ladies first, unfortunately. Your Excellency, the Honorable Chief Justice of India, Justice Surya Kant, Your Excellency, Sri Sanjeev Singla, Ambassador of India to France and Monaco, Mr. Vincent Vigneault, Président Commercial, Financial and Economic Chamber, Cour de Cassation, distinguished members of the Paris Bar, colleagues from the Indo-French Chamber of Commerce, fellow members of the Indian legal delegation, ladies and gentlemen, mesdames et messieurs. It is my deep privilege on behalf of the Indian legal fraternity to felicitate the Honorable Chief Justice of India, Justice Surya Kant, at this Indo-French Business Summit. Today we honor a jurist whose elevation to India's highest judicial office represents the very principles on which our bilateral relationship is founded: merit, integrity, and an unwavering commitment to justice under law. Justice Surya Kant assumed office as India's 53rd Chief Justice on the 24th of November 2025. His distinguished career began when he started practicing law in 1984 at the District Courts of Hisar in Haryana, moving to the Punjab and Haryana High Court in 1985, where he specialized in constitutional, service, and civil matters. He was designated as senior advocate in 2001 and earned the distinction of becoming Haryana's youngest advocate general in the year 2000 at the age of 37. He was elevated as a permanent judge to the Punjab and Haryana High Court in January 2004, served as Chief Justice of the Himachal Pradesh High Court from 2018, and was elevated to the Supreme Court of India in May 2019. He has also served as Executive Chairman of the National Legal Services Authority. His journey from a middle-class family in rural Haryana to the apex of India's judiciary embodies the democratic promise and freedom of opportunity that animates both our nations. Just days ago, Your Lordship delivered the Fali Nariman Memorial Lecture in Mumbai, where you stated that justice delayed is not only justice denied, but is justice destroyed. These words carry profound meaning for our business and legal communities, as commercial certainty requires timely justice and contracts are valuable only when they are enforced. Your Lordship's tenure at the Supreme Court has been marked by landmark judgments on transparency in political funding, freedom of expression, environmental protection, gender justice, and access to legal services. Your emphasis on mediation and alternative dispute resolution speaks directly to international investors, as these are mechanisms that preserve relationships, reduce costs, and allow courts to focus on cases requiring authoritative adjudication. You have called access to justice the constitutional North Star, and recently described India's constitution as a mighty river born from the confidence of hope, sacrifice, and vision, weaving its way through valleys of challenges and plains of progress. Evocative words, I'm sure you will all agree. Both the Indian and the French republics are founded on the principle that power must be exercised according to established norms, that no person stands above the law, that legal remedies must be accessible to all. India's common law heritage and France's civil law tradition represent distinct approaches, yet both converge on fundamental principles: constitutional supremacy, fundamental rights, judicial independence, and the proposition that the law must serve the people. And our partnership transcends commerce. India and France are pluralistic democracies committed to a multipolar world, more equal multilateralism, and strategic autonomy. We share a commitment to international law, peaceful dispute resolution, and the proposition that might does not make right. Your Lordship, you assume the Chief Justiceship when these principles face global challenges, and your leadership carries significance far beyond India's borders. When you uphold constitutional values, you strengthen democratic principles everywhere. When you ensure access to justice for India's most vulnerable, you deliver on the promise of equality before the law. And when you maintain judicial independence, you demonstrate that judges serve constitutions, not governments. Your Lordship, you have articulated a vision of the law that serves as a beacon for the global community of nations committed to constitutional governance. On behalf of the Indian legal community assembled here, I express our gratitude for your service to the Republic of India and the cause of justice. Thank you, Your Lordship, for gracing this gathering with your presence. Ladies and gentlemen, mesdames et messieurs, please join me in felicitating the Honorable Chief Justice of India, Justice Surya Kant.
Thank you, Akshay.
Merci beaucoup. Thank you very much.
Thank you. I request you to be seated on stage while I request Ms. Basado to say a few words before handling the medal to Honorable CJI.
Thank you very much. Merci beaucoup, Monsieur le Président de la Cour suprême indienne, Monsieur l'ambassadeur de l'Inde en France, Monsieur le Président de la Chambre commerciale, financière et économique de la Cour de cassation, chères consoeurs, chers confrères indiens et français, Mesdames et Messieurs, représentants d'entreprises, Mesdames et Messieurs, les étudiants. C'est quand même toujours une joie d'assister à la concrétisation de ce qui, il y a à peine quelques semaines, quelques mois, n'était qu'un projet organisé à Paris, à la Maison du Barreau, un grand forum franco-indien. Et nous l'avons fait. Ce projet est désormais une réalité. Et c'est vraiment un bonheur pour moi et pour le Barreau de Paris, évidemment. Merci de votre présence. Effectivement, j'ai eu la joie, la chance, le bonheur de découvrir New Delhi il y a à peine quelques mois, à la fin du mois d'août, accompagnée de Marion Couffignal, membre du Conseil de l'Ordre. Et toutes les deux, nous avons été accueillis par Monsieur le Président Prashant Kumar, que je remercie très sincèrement pour son accueil chaleureux à l'occasion de l'organisation de la 2e conférence sur l'état de droit. Et puis, lors de cette visite à New Delhi, bien sûr, nous avons eu également le privilège de rencontrer l'équipe dynamique, enthousiaste de la Chambre de commerce et d'industrie franco-indienne, dirigée par Payal Kanwar. Merci infiniment, Payal, parce que vous avez œuvré à la réalisation de ce projet qui est né ce matin à New Delhi. Nous étions toutes les 3, et puis le projet est arrivé, nous étions même 4, pardonnez-moi, et nous l'avons rendu possible. Merci beaucoup d'avoir œuvré aux côtés des équipes du Barreau de Paris pour rendre ce projet une réalité. Mais surtout, oserais-je dire, notre présence à New Delhi a été l'occasion et la chance de visiter la Cour suprême et de rencontrer les juges qui la composent. Alors, bien sûr, quelques mois après, quel honneur, vraiment quel honneur pour Paris, pour le Barreau de Paris, mais même plus largement pour la France, de vous recevoir, honorable Chief Justice of India, Justice Surya Kant. C'est un privilège et un honneur, et le Barreau de Paris souhaite le matérialiser en vous remettant aujourd'hui, au commencement de cette table ronde, la médaille du Barreau de Paris, qui est l'expression de la joie qui est la nôtre, de l'honneur que vous nous faites, du respect que nous avons également pour votre action. Merci de votre présence, et je me permets donc de vous remettre cette médaille du Barreau de Paris. Au nom du Barreau de Paris, de la Vice-Bâtonnière Carine Denoit-Benteux et du bâtonnier de Paris, Louis de Gauss.
Thank you, Vanessa. Could we please have a group photo with all our dignitaries? And Payal, may I also request, along with Madame Denton, to join us on stage? ladies and gentlemen, it is my distinct honor to now invite our chief guest, Justice Surya Kant, Honorable Chief Justice of India, to deliver the keynote address. Can we please have a huge round of applause? Thank you.
Mr. Sanjeev Kumar Singla, Honorable Ambassador of India to France and Monaco, Mr. Vincent Venu, Honorable President of Commercial, Financial and Economic Chamber, Court d'Association, Ms. Carine Denoit-Benteux, Vice President of the Paris Bar Association, distinguished Indian friends, Payal Kanwar, Director General IFCCI, Mr. Akshay Jaitley, founder partner of Trilegal, a very prominent law firm on the global map, Mr. Siddharth Batra, advocate on record in Supreme Court of India, Vanessa Buzzardo, former Vice President of the Paris Bar Association, Bhumika Indulia, media leader of the Bar Bulletin, members of the legal fraternity, very distinguished ladies and gentlemen. A very good afternoon to everyone. Bon après-midi. It is my proud privilege and profound pleasure to address such a distinguished gathering and in a country that has long believed in la force du raisonnement, that ideas are most powerful when tested through reasoned dialogue. While my original mandate was to speak on the intricacies of cross-border dispute resolution, the organizers were quite right to insist that we weave into our discourse the India-France Year of Innovation 2026. In truth, the two nations are inseparable. One cannot discuss the architecture of justice without considering the very structures it is designed to protect. And both countries, therefore, really are in very constructive deliberations on the issue of cross-border dispute resolution, as also in celebrating our Year of Innovation 2026. I shall therefore endeavor to harmonize these two themes, demonstrating how the synapse of our legal resolution is the essential raison d'être of our synergetic ambition. France and India bilateral relations is a theme, is a subject so close to heart of everyone present here. Therefore, before we delve into the complexities of statutes and strategic roadmaps, I invite you to join me in a brief exercise of reflection of that relationship. If we were to pause and look across the vast geographical distance that separates our two republics, could we name the commonalities that bridge the gap between Ganges and Seine? The Ganges, the Indian river, sacred to millions, flows from the icy peaks of Himalayas, nourishing the plains of India with life, faith, and culture. The Seine, meandering elegantly through France, cradles the heart of Paris, inspiring artists, philosophers, and dreamers for centuries. One may appear as a spiritual pilgrimage in motion, the other, Seine, as a poetic lifeline of art and romance. Yet, beneath these apparent differences lies a harmony of purpose. Harmony of purpose, both rivers are storytellers. Along their banks, civilizations have blossomed, kingdoms have risen, markets have thrived, and communities have found their rhythm. Each river mirrors the aspirations of its people, becoming not only a source of sustenance, but also a vessel of identity. France and India are heirs to civilizations that have contributed immeasurably to art, philosophy, and the human spirit. From the ideals of liberty, equality, and fraternity that inspired India's own freedom struggle to the intellectual and artistic exchange that continue today, our histories are threads in a single vivid tapestry. Our cultures, though oceans apart, speak the same language of creativity and resilience. This profound commonality of spirit makes it not only logical but indeed inevitable that our two nations should choose this moment to embark upon the year of innovation 2026. The relationship between our nations has long transcended the purely diplomatic. It is instead a multi-dimensional architecture encompassing everything from the sanctity of our defense and security cooperation to our shared pursuit of sustainable growth and advanced technologies. This strategic intimacy is mirrored in our economic vitality. We have witnessed a remarkable acceleration in our bilateral trade, which has more than doubled over the last decades. The footprint of French enterprise in India is both deep and enduring. France now represents a significant pillar of our foreign investment landscape, primarily through qualitative investment in our service sectors and heavy industries, ultimately signaling a vote of confidence in India's long-term stability and our shared individual and common industrial future and vision. The France and India, in a year of innovation of 2026, and if we talk in this backdrop of historic friendship and contemporary dynamism that we have conceived, the Indo-France Year of Innovation 2026, this initiative, my dear friends, is the culmination of our long-standing journey, a conscious commitment to place research, technology, and joint discovery at the very core of our partnership. The Year of Innovation is designed to be much more than a celebratory calendar. It is a platform for co-creation. By aligning the expertise of our respective industries, startups, and academic institutions, we are building a structural bridge for the future. Our focus is thus distilled into four essential pillars. And if I am permitted to briefly define, our first pillar is the culture of co-development. We are moving beyond the exchange of finished products towards R&D and technology transfer. By encouraging the scaling of innovative solutions across both markets, we are ensuring that an idea born in a French laboratory can find its commercial heartbeat in the Indian market and vice versa. Second, we are strategic priority sectors. Our efforts are concentrated on the challenges that define our era. We are looking toward artificial intelligence and digital technologies that respect human dignity, clean energy, and sustainability driven innovation to heal our planet and the transformation of healthcare and mobility for our citizens. The third pillar, I would say, is empowering the pioneers. A central focus of 2026 is the engagement of startups and small and medium-sized enterprises. We are collectively facilitating a seamless corridor of mentoring, market access, and investment, ensuring that the smallest innovators have the largest possible stage. And the fourth pillar, in my opinion, is the academic and research mobility. To sustain this momentum, we are institutionalizing the mobility of minds through joint laboratories and university collaborations. We are ensuring that the next generation of Indian and French researchers are not just colleagues but co-authors of global future. Ambassador Mr. Singla also very briefly pointed out the robust friendly mechanism between India and French that is developing on day-to-day basis. In this backdrop, when I'm talking about the India's legal renaissance, let us think and visualize that how India has progressed well in the fields of arbitration, mediation, and a very speedy and expeditious disposal of commercial disputes with absolute predictability. Such remarkable movement must therefore be supported by a robust institutional scaffolding. This brings me to the second strand of my address, namely the question of cross-border dispute resolution, particularly in the context of arbitration, mediation, commercial courts disputes, and also in the superior courts of, as we call in India, the high courts at the state level and the apex body, the Supreme Court of India. In any ecosystem defined by innovation and transnational collaboration, the emergence of disagreements is not a failure of design, but a natural consequence of complexity. What becomes essential, therefore, is not the elimination of dispute, but the presence of a credible, efficient, and principled justice delivery system which must ensure, as I said in the beginning, a predictability, a timeline, and cost effectivity. And I can say proudly that the rejuvenated, a new thinking of the Indian justice delivery system very positively, very effectively, very confidently respond to all these three expectations. This brings me to a concept rooted in French thought and so beautifully articulated by the pioneering mathematician Blaise Pascal that I believe is deeply relevant in our today's context and discussion. Excuse me for my French pronunciation, but if I am able to speak a little bit of it. He said, and I quote, La justice, so la force, et tom pavi son, la force son, la justice, et tyrannique. If I translate, he said, justice without force is powerless, and force without justice is tyrannical. Very beautifully explained everything. In the context of, therefore, cross-border innovation, the notion of force has undergone a profound transformation. it is no longer defined by military might, nor even by economic dominance. Today, force manifests as innovation, the ability to create, to disrupt, and to reimagine the future across borders and disciplines. Yet innovation, untethered from a sophisticated and agile legal architecture, remains inherently fragile. Without a conception of justice capable of engaging with contracts written in code, with platforms operating across jurisdictions, and with disputes that traverse continents at digital speed, innovation risks becoming precious rather than transformative. It becomes actually precarious because it can cause a lot of complications. For what ultimately defines a legal system, indeed, what defines a civilization is not the absence of conflict, but the wisdom, restraint, and legitimacy with which that conflict is resolved. It is against this backdrop that I now turn to a brief overview of the alternative dispute resolution framework currently operative in India. Over the past decade, India has undergone a profound legal metamorphosis, gradually moving away from a traditional litigation-centric culture toward an increasingly institutionalized alternative dispute resolution mechanism. In the matter of arbitration, India's modern arbitration framework is anchored in the 1996 Act of Arbitration and Conciliation, a statute which is modeled on the UNCITRAL model law on international commercial arbitration. This act represents India's decisive turn toward harmonizing its domestic law with global standards. Under this framework, parties enjoy broad autonomy to determine the seat, procedure, and language of arbitration. Equally significant is India's commitment to the New York Convention on the Recognition and Enforcement of Foreign Awards. The awards rendered in convention states, including France, are enforceable in India as a decree of court. And let me share with the entrepreneurs and those who are in the business partners in India that any award passed between a parties, say a French or any Indian legal entity, any corporate entity, that award is respected as much as a decree passed by the highest court in India, like a money decree. And the Indian mechanism is effective enough to ensure that such a decree is respected, it is executed, that and whatever benefit is drawn from such an award is immediately delivered to the person who is entitled to. The successive amendments in the Arbitration Act of 2015 and 2019 have ensured the parties' neutrality and autonomy. These proceedings have been very summarized in terms of the procedural part, and more particularly, the 2019 amendment is historic in the sense that in the arbitration awards, the interference by courts has been minimized. The law in India is now well settled that once an award is passed by the arbitrator, unless it is found to be suffering with some element of perversity, or only when it is found against the well-known public policy, only the court, then in these two limited grounds that the courts can interfere. Otherwise, any award passed by the arbitral tribunal has to be respected and its execution and full respect has to be ensured. Through the judicial intervention also, the Supreme Court of India has taken very recently important decisions only to liberate the arbitration proceedings from the judicial interference as also from the super technicalities. Say, for example, in India, a view was taken earlier by the courts that if the arbitration agreement between the parties is not adequately stamped, that means if you have not paid the stamp duty charges, such an agreement will not be admissible and arbitration proceedings cannot be initiated based on that. But we have overruled that decision. 7 of us sat together, I am party to that judgment, and we have said that no, even an unstamped agreement, once it reflects the intention of the parties to go for arbitration, that agreement will be binding irrespective of the fact that it has not complied with the domestic law under which such an agreement was required to be registered or some registration charges were required to be paid. Similarly, on my reference only, ultimately the Supreme Court of India has also explained the doctrine of group companies. There have been investors in India from the foreign nations who found that one corporate entity in India having subsidiary companies, the agreements are sometimes entered into between the, say on hypothetical basis, between a French entity and one of the subsidiary in India. And eventually when award is passed in favor of the French entity, the objection used to be taken is that you can execute it only against the subsidiary company. And if the subsidiary company does not have the sufficient values available, the resources available, the funds available, where to go with that award? And the award used to become only an empty formal decree. Therefore, in one of the matter where I disagreed with the earlier judgments, I referred the matter, and pursuant to that reference, now the Supreme Court has held that the group company doctrine can be invoked in such like matters. So what is that group company? If you are entering into, say for example, in India, you have very prominent families like Tata, like Reliance, like Adani, like Vedanta, like any big names. Now, if you enter into an agreement which having an arbitration clause with a subsidiary company, you can execute your award even against the principal company. So that umbrella principle, that when the subsidiary is liable, so will be the principal company will be liable. So that principle has also been, now that law has been developed in India only with the idea to ensure, to build confidence in the foreign investors and to ensure that the entity of the firm, the legal entity of the person with whom you enter into the agreement is not so material, it is the overall group of companies that would matter for the purpose of respecting and executing any decree or award passed in your favor. Now, the doctrine of minimal judicial intervention has also been developed by Indian Supreme Court. As I said, only on 2 grounds that the courts are now rarest of the rare cases would like to interfere. Otherwise, any international award is absolutely respected and is taken as an award passed by the binding, the legal form of India. This overarching principle that emerges is a focus on minimal judicial intervention grounded in a commitment by India in the independence and integrity of the arbitral award. I must say, as I was earlier pointing out, the parties are at liberty to have complete autonomy while entering into an arbitration agreement in India. It is your choice, you want to hold the proceeding in India or in Paris. It is your choice, you want to have any third platform also. You can, even while holding the arbitration proceeding in India, you can still enter into a commitment that the law of France will be binding on the Indian entity. And even while say participating in the arbitration proceedings in Paris, you can still follow the Indian law. So that absolute discretion has been recognized, restated, and reinvested in the parties to any agreement. Now, beside the arbitration, my dear friends, the arbitration has its own cost. Arbitration is not, you pay to the arbitral tribunal, you pay to the consuls, you pay to, you incur some expenditure. And arbitration being a procedure, a law which provides a procedure to be followed, like conventional courts where you have to lead the evidence, you have to argue the cases, and it takes some time. Therefore, Even above the arbitration, in India we have developed the very strong mechanism of mediation. In 2023, Indian Parliament has enacted the Indian Mediation Act of 2023. Under this act, we have provided a platform of mediation where the parties can, with the assistance and help of a trained mediator, can amicably resolve their dispute. At one point of time before this 2023 Act, there used to be some confusion, some unpredictability, some suspicion that if a settlement takes place through a mediation, whether that settlement will be, after the settlement is signed, how to enforce it. And therefore that uncertainty has been effectively answered in India by the legislation by providing that once you enter into a settlement and it is duly signed by the parties, that settlement will also be treated as a court decree and you can enforce it through the mechanism of, like any court, any decree passed or any judgment delivered by a court, the same fashion and the same manner you can enforce even a mediation settlement also. If some of you, I know that my Indian friends, they are well aware, but if any one of you have in recent times visited India, you might have heard or you might have seen it somewhere in global map also, that last year, when I was executive chairman of the National Legal Service Authority, I was also chairman of the Supreme Court Mediation Committee. At that time, I launched a project which was called as Mediation for Nation. And that project has become so popular in India that I can proudly say that mediation is now in India known to every household, it is known in every street, it is known in every village, it is known in every town. And there has been so much response from the stakeholders, from the business communities, from the legal entities, from the corporate and public sectors, from the insurance company, from the banks, that they have been asking me that we would like to set up our own mediation cell, and for that please send us some trained mediators. So the challenge which I faced in India was how to provide trained mediators. And eventually, on assessment, I found that in India, for the disputes which are identified worth trial before mediation, I'm talking of the cases where we found that there is a hope of amicable settlement and parties can mutually resolve their dispute. Having identified those cases, I realized that I need 2.5 million trained mediators in the country, whereas I had only 31,000 mediators at that time. So therefore, in Supreme Court, we again took some very effective, very salutary and very emergent kind of steps, realizing that we are in dire need of the trained mediators. And therefore, online mediation training programs were introduced, were established, and that mechanism has also proved to be very successful. Now, we are every month, in a way, we are training thousands of mediators. Of course, the training program runs into a couple of weeks and months. So, but on average basis, every month now we are having a team of trained mediators whom we are sending in different parts of the country, and the response, ultimately the settlement of the disputes which were pending in courts and which were part of the total pendency which the Indian courts are facing as a challenge, those have been effectively reduced thanks to the success story behind mediation. So when I am here before you, I am also offering that in addition to arbitration, which is of course a cost-oriented the process of adjudication, we have a very effective alternate in India, that is of mediation, and we have trained mediators, and we were, former judges, retired judges, former bureaucrats, chartered accountants, lawyers, the engineers, the architects, from every walk of life, people are getting training as mediators, and we have a big pool of well-trained, experienced mediators who sit between the parties, try to resolve, so that the parties can go with an adjudication where you have a win-win situation, both sides go with a smiling face, the dispute is immediately resolved, the cost is minimum, and the time taken is very short. So the predictability is also there because such a mediation settlement is also enforceable in law. The third thing which I want to share with you is that in India, we have also realizing that the startups, the foreign investors, the middle and medium level entrepreneurs, if they are to be attracted in India, we have to ensure that the commercial disputes, even in the conventional method, when I'm talking of conventional method, I'm talking of the dispute resolution mechanism in courts, that how you effectively decide those courts. Therefore, in India, a special law, that is Commercial Courts Act, has been enacted, and that law is now effective on pan-India basis. In every part of the country, we have established commercial courts. These courts deal with only the commercial disputes. These are exclusively professionally trained courts, only meant to ensure that commercial disputes, if arise between the parties, and the parties do not want to go for arbitration, the parties have failed in mediation, or they do not want to have a settlement, but they want an adjudication. In that event, we have, as a third tier, we have provided the commercial courts for the purpose of speedy and expeditious disposal of the commercial disputes. The next salutary step that we have taken, so for example, you have an arbitration award in your favor, you have a mediation decree in your favor, or you have a decree from a commercial court also. Ultimately, the other party, the suffering party, the party who has suffered the decree, they have a right to file an appeal. So sometimes you are stalled in appeal. The matter is pending before the appellate court, and that delay which you are apprehending at the original stage, that delay might occur at the appellate stage. To respond to that, in high courts also, we have now established exclusive commercial appellate benches. In every high court now there are dedicated benches where the only commercial disputes are listed, and once the commercial courts decide, once an arbitration award is passed, the matter straight goes to those appellate benches, so that the appeals are also decided out of turn, expeditiously, and within a prescribed timeline, so that there is no element of uncertainty. All these steps have been taken with a view to ensure that any investor in India, any startup who comes to India, he is welcomed, he is ensured by the other aspect which I just very briefly want to highlight before you is that Indian judiciary, and when I'm talking of arbitration, I'm talking of mediation, I'm talking of commercial courts. Please keep in mind, all these institutions are run, controlled, and governed by the Indian judiciary. And as far as the Indian judiciary is concerned, it is creation of the Indian Constitution. The Constitution of India provides three-tier judiciary for the country: the district judiciary, the high courts, and the highest court is the Supreme Court of India. Now, in this three-tier system, you will also find from the Indian Constitution that there is a doctrine of separation of power. Our legislature, our executive, our judiciary are three independent pillars who maintain their own complete autonomy and absolute independence in terms of the constitutional framework. Not only this, the Indian Constitution further expressly provides that there shall be a separate, independent judiciary in India. The resultant effect is that the Indian judiciary, and in terms of her constitutional value, in terms of her constitutional ethos, in terms of our constitutional morality, we have firmly believed, we have firmly enforced, we have firmly ensured in all times that the rule of law, democracy, the the principles of natural justice, the principle of equality, the principle of liberty, all these principles which are very proudly enforced and which are integral part of the France judicial system also, and which are equally professed in France also, these are also in India duly protected. Not only they are equally promoted also. So with an independent judiciary working there, and these speedy mechanism of the resolution of disputes of different nature are made sure and made available to the smallest investor to the highest one, the largest one. All different kind of form are operative in India. I am here to ensure you that all those who are keen to come to India for the purpose of business, for the purpose of investment, for the purpose of industry, for the purpose of any kind of the innovative business ideas, what I, as a head of the India's judiciary, I want to ensure you that India is the most preferred destination at this time, where not only our country is progressing, it is in view of the established cooperation, the relationship between the two countries, the commitment to each other, the understanding between the two. It is my opinion that India ought to be the most preferred destination for any friend from France to come there and to see how the reality is taking place. The path forward is that India and France look forward in the year of innovation of 2026, and the imperative before us is not merely to innovate together, but to institutionalize the trust that such innovation demands. The future of cross-border dispute resolution between our two nations must therefore be shaped by cooperation that is deliberate, structured, and forward-looking. A first and particularly promising avenue lies in the establishment of perhaps joint arbitration and mediation panels comprising of professionals trained across civil and common law traditions. Such panels, as the President Vincent also pointed out, that India follows common law, and here in France you follow the civil law practices, but both procedures, as my friend would agree, eventually believe in natural justice, in fair trial, even in the civil disputes. And so following that, I think the panel, arbitration panel of professionals, when I'm talking, that such panel would bring not only technical excellence, but also the cultural and jurisprudential fluency necessary for resolving disputes that traverse legal systems as seamlessly as they traverse markets. Equally vital is the deepening of institutional partnership between Indian arbitral centers and Paris-based institutions. Through shared procedural standards, joint training initiatives, and co-administered proceedings, these collaborative steps can create dispute resolution forums that are once globally credible and contextually nuanced. A third pathway, in my opinion, is sustained judicial and academic exchange. Fellowship for judges, arbitrators, and scholars engaged in comparative alternative dispute resolution would foster a shared judicial sensibility which values restraint, efficiency, and respect for party autonomy, irrespective of the jurisdictional boundaries. Innovation, however, increasingly unfolds in digital space. Technology-enabled online dispute resolution therefore presents a natural frontier for Indo-French collaboration, particularly for small and medium enterprises and startups. joint ODR pilot projects can ensure that access to justice evolves in tandem with technological advancement rather than trailing behind it. Finally, cooperation can be anchored at the normative level through treaty linked ADR protocols, embedding mediation and arbitration clauses within bilateral commercial frameworks. I firmly believe that together these pathways reflect a singular vision, namely that as India and France enter a new phase of innovation in 2026, they do so supported by a dispute resolution architecture that is not reactive but anticipatory, not adversarial but principled, and not merely efficient but enduring also. As the curtains draw to a close, ladies and gentlemen, I wish to take this opportunity to extend my sincere gratitude and felicitation to the Indo-French Chamber of Commerce and Industry and to the Paris Bar Association for convening this distinguished gathering. I am confident that the reflections shared today will not only enrich our collective understanding but will also help set the year of innovation on a course marked by thoughtful engagement, sustained collaboration, and meaningful progress. The relationship between France and India is not a creation of convenience. It is bond forged over centuries. Today, standing on the shoulders of this history, we face a world transformed by uncertainty. The forces of disruption and geopolitical tension threaten to destabilize the very framework of international cooperation. In such a world, the France-India relationship and partnership is not a luxury, it is a lifeline. United by our shared belief in democracy, the rule of law, and the pursuit of a peaceful and just global order, our nations possess complementary strength. If I may, let me make one final attempt at speaking my broken French to capture the spirit of our study and deliberate progress. I believe it is Patita pati le azo fait son nid. I am told if you translate it, it should read, little by little, the bird builds its nest. For decades, India and France have been precisely that, patient builders, carefully and consciously weaving together a shared nest of trust, common values, and strategic confidence. As we stand at this precipice of the year of innovation 2026, we are no longer just building the nest, we are mapping the sky in which we fly. Like twin wings of a mighty bird, France and India rise together, their majestic forms silhouetted against vast canvas of a turbulent sky. These wings, powerful and graceful, catch the winds of history, each gust a whisper of the past, and each bridge a promise of future. In this restless world, where storms of uncertainty rage and the seas of change churn into relentless force, France and India create harmony in flight. Their wings beat in unison, a symphony of trust and strength that echoes across the heavens. Each nation, a guardian of its own dreams, yet bound by a shared vision, balances the other with a gentle touch. In this dance of destiny, my dear friends, France and India are not merely partners, they are kindred spirits. As they continue their ascent, their wings become a beacon of hope in a world yearning for harmony. Merci beaucoup. Thank you very much.
Thank you, Honorable Chief Justice, for that inspiring and thought-provoking address. To conclude and formally close the inaugural session, I would like to invite Ms. Bhumika Indulia, Editor-in-Chief of the Bar Bulletin, for the vote of thanks. Can we please have a round of applause?
Good afternoon, everyone. Bon après-midi. Namaste. After a powerful start that crossed jurisdiction, institutions, and borders, it is my privilege to bring us back to the room with a vote of thanks. I, Bhumika Indulia, Editor-in-Chief, The Bar Bulletin, and we are delighted to be the media partner for the first edition of Indo-French Legal and Business Conference. We are deeply honored by the presence of our chief guest, Honorable Justice Surya Kant, Chief Justice of India. His address was a powerful reminder that innovation lies not only in technology, but in institutions and cooperation. Also reflecting us to the effective medium of dispute resolution, that is mediation, we are truly grateful for his time and wisdom. My sincere thanks to Ms. Payal Eskanwar of IFCI and Ms. Carine Denoit-Benteux, Vice President of Paris Bar Association, for setting a warm and forward-looking tone and for hosting us here today. I also thank His Excellency Mr. Sanjeev Singla, Ambassador of India to France and Monaco, and Mr. Siddharth Batra for grounding our discussion in the broader Indo-French diplomatic and economic partnership. We are grateful to Sir Vinyo and Mr. Akshay Jaitley and Ms. Vanessa Bosado for the gracious felicitation of our chief guest for helping us conceive this conference. Our heartfelt thanks to the conveners, Ms. Rishika Roy, Ms. Feni Tobin, Arushi Gautam, and Mr. Siddharth Batra, as well as our event partners, Denton Sleek Legal, Tri-Legal, Vishwanathan and Company, and the France Asia Foundation for all the support. When India and France speak about law and innovation, the conversation is never just technical, it's visionary. With that, I extend our sincere thanks to everyone. The conference has just begun. Please stay here for our upcoming sessions. Thank you.
Thank you, Bhumika. We'll now move on to our panel discussions. We'll keep 25 minutes per panel. We'll try to fit in within 25 minutes. And before we invite our panelists, I would request our dignitaries to kindly take their seats in the front row. Without further ado, I invite Mr. Prashant Kumar, President of the Bar Association, moderator of the first panel, and our panelists, Ms. Lubinisha Saha, Head Legal and Compliance South Asia and International Airbus, and Chairperson of the IFCI General Counsel Committee, Mr. Matthew Perron, General Counsel Cyber Data and AI, Schneider Electric, Ms. Neha Vardhan, Partner, Corporate Tri-Legal, and Mr. Amir Faruqi, Indo-French Avocat from Dentons. I understand you might want to meet our chief guest, but you will see him at the cocktail in the evening, so I request your attention for the panel. Mr. Kumar, we'll have 25 minutes for the panel.
Hello. Good afternoon, friends. After a very rich and evocative inaugural session, it is my privilege to host this first panel discussion on tariffs, global economy, and geostrategy, implications on global trade. Though we are talking about geostrategy and global trade, and tariffs, which were more an instrument to balance trade, to protect domestic industries, have taken a coercive turn in recent times. But I think in the wake of the finalization of negotiations of EU, India, FTA, we should more look at forces, at trends which are constructive. Geopolitics is relevant here only because for 2 decades those negotiations were lingering on, and perhaps it is this atmosphere which gave it a push, and now we have something right there which is going to endure and provide certainty. And it comes as a huge counterpoint to what is happening around today in terms of current global environment. And that's why the president of European Union in Davos happened to make a remark that this is mother of all deals, not just by way of economic relationship with 2 billion people coming together, but by the sheer powerful message that it is the concrete, enduring structures and relationships which continue to matter, which are going to matter, and which is going to define how the world is going to cooperate with each other, work with each other on predictable norms, on shared principles, on shared approaches. So this panel, I have very eminent panelists. We have general counsels who have actually delved deep into these issues and held them. And we have an Indo-French practitioner who bridges the gap. He's a sort of a bridge. He works with Denton Legal. And we have Sneha from Trilegal. So we have a corporate law practitioner, we have 2 very eminent general counsels, and we have an Indo-French lawyer. So I think a very balanced panel. And to make things easier, we have just, we are going to keep the introductions very short because it's a 40-minute panel. So our first panelist is Luminisha Saha. She is head legal and compliance, South Asia and international for Airbus, and chairperson IFCCI GC committee. So her experience is not only limited to India and France. She looks at South Asia and other regions internationally. I was told around 5 regions. So she comes with a very big background, cross-cultural experience. Then we have Matthew Perron, and he's General Counsel, Cyber, Data, and AI with Schneider Electric. Schneider is a household name in India as well. We know the Schneider products, and his coming from specifically areas like cyber, data, and AI gives what is a future-oriented outlook in the whole discourse. Then we have Amir Faruqi, who is Indian-French advocate at Dentons. And with the collaboration of Paris Bar and the Bar Association of India, we wish to see that more and more Indo-French professionals emerge out of exchanges, out of training, and out of bilateral relationships between the two bar associations. And then, of course, Sneha Burden is a partner corporate in Trilegal. So for ease of discussion, we have just formulated 3 or 4 questions. And if time permits, we'll try to invite a question from the audience as well. So the first question, of course, is in the light of on 27 January, we just finished negotiation on India-EU FTA. Now, we have been looking at tariffs in a very different way, as I said, in recent times. But then, you know, FTA addresses tariffs as far as EU and India is concerned in terms of reducing tariffs, reducing barriers. But then there are other issues also, which are non-tariff barriers in economic relationship and trade relationship. So, Matthew, I'll first go to you to say that how do you look at the FTA and the overall setting?
Thank you, Prashant. First of all, an honor to be here, myself and for Schneider Electric, to be part of this first conference of the Indo-French Chamber of Commerce and Legal Business Conference. First of all, I think that it is important to measure, I guess, the scale, as you recalled it, the scale of such an agreement when it comes to the topics that it wants to solve. Quite ambitious, I would say. From a European standpoint, we are with an FTA that address as many chapters as the one that the agreement have been signed, for example, with Korea, Japan, or Canada. So it gives the scale of the intent. And from an Indian perspective, as far as I'm aware, it addresses even more topics than the other FTAs that India has been signing with, notably Australia or the UK. So as you recall, so with the scale, number of people concerned, the value in terms of GDP that it represents, we are already at a very high level of ambition for that agreement. And we can see through the different chapters, so the 24 chapters that have been discussed between the two parties, that it addresses obviously the tariff that can be seen as, as you mentioned, because of the geopolitical situation as one of the main interest, but also it addresses the technical barrier to trade, which is one of the most important part as well for some companies. Sustainability, good regulatory practices, intellectual property, that is of utmost importance as well for private companies, as well as notably public procurement. Then I think that in order to assess, notably answer the question if tariffs remain the main concerns, it will depend from where you are seeing that question. I would say for a group like Schneider Electric that I represent, we've been establishing our first businesses in India more than 60 years ago. So in the 1960s, even before foreign entities were able to establish themselves in the country through a JV with Tata Group, then moved to full establishment in the country in the 90s, and then going through an acquisition of electrical and automation part of Larsen & Toubro. So meaning that from our perspective, tariff is maybe not the main concern that we would like this kind of agreement to address. The non-tariff space for us is really the important part of things, because this is the part where we see some risk for our supply chains. So we see that agreement more like a legal risk management framework, enabling notably companies to ease their integration in the country.
Thank you, Matthew. And Amir, I'd like a very brief remark from you. That is that Schneider has been an established player in India from 1960s. What do you think that with the FTA now, more companies will see India as an attractive destination to come and set up manufacturing and businesses?
So, FTA, somehow, we all are talking about tariffs, but it's not just about tariffs, actually. It's bringing trust, clarity, and predictability somehow. You'll hear that quite a lot, I would say. But the fact that there are companies that are investing on both sides, whether it's in France from India and Indian from French in India, there is always this unpredictability on the laws, and you would see that, for instance, if we talk about custom clearances, for Schneider Electric, it's a big matter in the sense where the FTA and the tariff is pre-secondary somehow, I would say, because a component going through, let's say, a port in Chennai may be interpreted as a part, while if it goes in another port, let's say in Mumbai, it may be considered as a finished product. And then there would be above these questions of tariff, duty that could range from 10 to 28% on the product, which is a huge subject, actually. So especially for a player like Schneider Electric, or I'm thinking also of Legrand, they try to plan their whole sites and the supply chain, global supply chain sites. And according to these FTA, they're trying to bring more clarity whether it should be interpreted as a part or as a component and so on. So it really impacts on their businesses, and of course that FTA would be bringing that kind of clarity and predictability somehow.
Thank you, Amir. Now the main
Sorry,
thing,
Prashant, if I could just add 2 bits to it. For your point on 1960s, when Schneider came, and in 1991 when it opened up and then you could do investments in India, the FTA right now is not only talking about FTA tariffs and non-tariff barriers, right? There's a specific investor protection agreement which is being negotiated and which will also come in place, which will give you the system of how investor disputes will be handled. And that's something which is very important in respect of any EU country and India, because since 2017 or 18, when all the agreements got terminated, which meant every dispute was supposed to go through the domestic courts in India before it could come to an arbitration outside or an international arbitration. That's been placed and that's been discussed in the investor protection agreement. And second, Ahmed, what you were talking about customs, just for what you were talking about customs, there is now a single window custom clearance, right? Which is a faceless custom clearance, where the custom officer doesn't need to be sitting in Mumbai or Chennai, which should be addressing the issues which people have been facing up till now. So that's something which we should look forward towards.
Thank you, Sneha. Luminisa, I think the other hot topic is about supply chains, shifting of supply chains, diversification of supply chains. Now, Airbus has quite a large footprint in India. And, to establish MRO, to establish manufacturing, everything faces all these challenges and constraints. So can you, with your own experience and examples, say what has been so far now, your experience, and how do you look that it will be addressed.
Okay. Well, thank you, Prashant. I had a different pitch, but I'm going to change it now, seeing the audience, and tell you a story. I think we all like stories. The story is about flying and aviation. There's no prizes for guessing that. It's a very short story, so I won't take too much of your time. Aviation in India. So when I joined in 2019 in Airbus, we were just 500 people in my organization. Today we are 3,600, and we can boast of 2 assembly lines, one in military aircrafts and one in the H125 helicopter facility. Very interesting facts, more on the story. 100 aircrafts will be delivered every year for the next 10 years to India. That's the volume coming in. With that, you'll need pilots, training facilities. We've done a JV with Air India. We're looking at 10 simulators. So I'm just giving you the ecosystem. Then regional connectivity. Airports are going to be at like 500, 600 plus with the UDAN scheme. So the volume and the magnitude of the length of aviation is only going to, upscale. Let's talk about sourcing. More numbers. Today, it's at about 1.5 billion from about 300 million 4 years ago. And it's not just engineering services and digital services, it's actually strategic sourcing. We're doing our doors from India, cargo doors, our neo doors. So what I'm trying to tell you is that it's no longer a question of cost, it's competence, it's quality. And the story has actually changed from let's sell to India, then let's buy to India, strategically source from India, but now let's be an industrial partner to India. So the 2 assembly lines I spoke about, one is in Baroda and one we have in the south. Both of them are with industrial partners, with local partners. So it is overall ecosystem opening up for us as well. So all of these are putting the thread on India, not just make in India, but make by India, which is where India is kind of pushing the narrative too. And a very interesting fun fact in the story is, if you know a big plane, 80% of the parts are bought out. So we get all these parts from a global supply chain, and we fly them in a beluga, and we put them all together in our sites, and then we sell it. So you can imagine the complicated supply chain when you have parts from different places. You have no Russia suddenly, trade compliance, export control. So in this narrative, India has a big role to play in not only supporting its ambition, but the global ambition. So the moral of the story is, coming back to the story, is that it's a great place to be, and we've really solved for the big stuff. Now, what is not going well? I told you the good story. I think the FTA, as you said, Sneha, provides the structure. So the cost of entry is sorted, but the cost of continuity as to how the customs will work out. For example, EASA and DGCA, very good, but we have different standards. So when a part is not certified well, or it's complicated in certification, the poor supplier has to jump multiple regulatory hoops to get that one part, which for me is very critical in my doors or my wings. So the next level is the cost of continuity, regulatory uniformity, and simplification to ensure that this operating system we've built has the right apps in it.
Thank you. And it is, even in your personal experience, most of the luxury brands from France and all, when you have some defect in the product and it's a guarantee period, they will rather replace it than, go through all the legal channels to send it back, get it repaired, get it back in India and give. It's not just time consuming. What they will face becomes such a heightened cost that, it is thought it is better to give a replacement product. So yes, all these things need to be worked on the ground. How the Indian bureaucracy is going to implement the FTA is a big question mark. And that is where, working with the local profession, local law firms, and knowing what are these hoops and loops and how to smoothen them is an equally important task than just having an understanding in place. And I think that is where these kind of panels and these initiatives are going to help. So anyone like to add on this? Okay. So now we go to the third aspect. That is, these have been the elephants in the room. QCOs, licensing, and regulatory predictability. So I think, Sneha, you have been raring to go on this. So.
Okay, so before we discuss what QCO and what licensing and regulatory, what confusions are there, right? I would want to just bring it back, like historically, when did actually QCOs start in India, right? It's very important to note that. QCOs happened in India, quality control orders came into India only in 2019, okay? Till that time in India, only pharmaceutical products and food products required some kind of testing before selling in the Indian market. That's 2019 and come to 2026. You have around 800 products which are on this QCO list, okay, which need certification and testing before they can be sold in Indian market. That's what a QCO is. Now, if I try to draw some inference between what is already in EU and exists in EU and what a quality control order in India is, I think the best possible may be a harmonization of product list, right? That's been there in EU forever. You cannot sell a product which does not have a CE mark. And what's the core pillar for these harmonization lists? The core item here is quality, safety, health, and environment. That's exactly the core pillars on which QCO is also built on. But an interesting fact, see, we just started in 19, so we have to also learn this rope, right? We have added two more things in this. One is relating to national security. And second, because there can be deceptive trade practices, right? There can be deception, unfair trade practices in a lesser developed market in India. To control that also, QCOs come into play. Now, what has been discussed and argued, and which is not understanding for a lot of people, is these quality control orders have also been brought into for an intermediary product. This is not only for a finished product, but before the line of the finished product, there are certain testing which is required. Yeah? So what's been questioned is this testing important? Is this getting down to the core pillar of safety? Or are we trying to create a market barrier? Or is this a negotiation point in FTA when India wants to negotiate with some country which already has an harmonization list or has carbon emissions, which we need to figure it out in Indian manufacturing facilities? So that's the interesting piece. But given we've worked with few companies and corporates who've trying to enter into India, what are the 4 or 5 important factors? And I don't think anyone in this room would disagree that any country who's trying to have quality in place is something wrong. I don't think anyone has a problem with that. Anybody having safety in place, is that wrong? I don't think so. But what a company tries to see, are you moving away from the clear intent of safety and protection? Are you trying to get into something else? The interesting bit again here is, in 2025 November, there were around 14 QCOs which were withdrawn by the Indian government. Not seen ever, but they were withdrawn. They were withdrawn because they were on intermediaries. The companies came together, a lot of companies came together and said, these QCOs which have been implemented are not trying to increase the safety product. The final product will give you the same safety. I don't think so an intermediary level is required. And, sorry, Prashant, do you want to say something?
No, thank you. Sneha, because we have limited time on this panel.
Yeah.
So good, you have given the background. But the main question is 2019, they were brought in.
Yes.
And do you see there was a capacity to process all these?
No.
Was a specialist capacity created?
That was going to get created. There were already systems in place.
No, going to, but it was implemented.
No, it wasn't. Yeah, it was implemented. But that time the orders were very limited in 2019. It's still in the process. I'm not saying that we've learnt it. We're still learning it.
So at the government authority level, the capacity to process.
That's correct.
And clear guidelines. How
Correct.
do you see them? Do they exist in the manner that they can be processed very efficiently and with the clear objective in mind?
So they may not, if you're saying whether they are all in place right now, they may not be exactly all in place, but they are in the process of being in place, right? There used to be a system where you needed import guidelines were different, they were marked differently, products were marked differently, but that's been centralized now, which has been recently been changed, right? There are customs, which he was also talking about, whether you come to the port of Gujarat or Bombay or Chennai. It used to change because it was a state level requirement, but that's changed now in India. It's now national, right? Then there are national single window system, which means clearances are faster. Then there's a state clearance window where, for example, I won't say that all states have agreed to it, but there are states like Maharashtra and Gujarat who have a single window clearance for all your approvals, right? So there are, I won't say there is nothing at all in India before QCOs came in. There are systems in place. There are systems which are getting developed. And that's why this FTA is extremely important, because this also talks about a working committee which will be framed to see and analyze a QCO before a QCO is implemented, before a product comes on that list.
Thank you, Sneha. Luvinisa, you want to add something? And I think Matthew wants to. Yeah.
If I may add.
Just keep it very short.
Yeah, please. Sure. For me, I mean, it's a perception, and maybe I'm wrong. I feel like standards are the new tariffs. If you look at, on the flip side, let's say Tata Motors, they acquired last year a segment of IFCO that gave them access to world-class electrical buses. And you would see that for them, it's not the tariff that is the challenge. For them, it's the fact that there is 27 different homologation rules. There is 27 different charging standards. There is 27 different technical rules that needs to be understood. And so somehow even for Indians investing in France or in Europe, it feels like they're running a marathon across 27 different specific rules, okay? So somehow that FTA is trying to harmonize this. And we're facing the same on the Indian side, and we're facing the same on the French side. So the FTA would be bringing that harmonization soon.
Thank you, Amir. Matthew?
Yeah, in 2 words, what would be important for this working group to kind of try to achieve at least, and we see at least some positive move right from the beginning. It's some kind of mutual recognitions of, notably when it comes to testing of the products or the following up of the norms, and alignment as much as possible on international standards and norms that could help hugely to achieve.
And now on top of that, how CBAM is going to overlay on all these complicated things is something I think is out there as well. So anybody will like to address that?
Well, maybe just one point on that. It's a nicely worded chapter with lots of let's meet, let's talk, let's love each other, which is very nice. I think the whole point is that it's a green premium opportunity. And I want to talk about industry again. Like at IBAS, I have, so aviation overall is 2% of CO2 emissions, only, a surprising fact for some of you. So scope 1 and 2 targets also which we have, and then there is the hydrogen-powered aircraft and the sustainability goals around building an aircraft with SAF. So while all of this exists, how can we have the Indian supply chain which will support the global supply chain and have recognition for their carbon credits and have the mutual recognition? So we have to see how that plays out, but the idea that's an opportunity. And if we can leverage that, then the entire supply chain moving, the ecosystem, and the common sustainable goals, that can move forward in the right direction. That's what I have.
Thank you. But I think a lot of work is required here, where we map the Indian competencies and the European standards and all. So it's going to be an ongoing process. And I will just add this, that, Paris is city of love. And India is a very snooty mistress in terms of regulation and all. It is not just that you go and quote one time. You have to, put up, bear with her, understand each one of her behavior, her quirk, what it means. You have to interpret it you have to keep on guessing how to respond. So, but once you do that, the reward is enormous and huge. So friends, any question from the audience?
over 60 years, 40 years to then, wait for the results to come in. What happens is there's a lot of fatigue that comes in for small and medium industries. Now, I've seen some of those reports in the mother of all deal, some of them going into 5, 10 years. Yes. Give some hope to us. What can I take back to my small, medium businesses to say, wait, you do not have to get tired or fatigued. Hope's there. What would you say to them?
So one of the things in the FTAs is about international alignment, at least on the QCO side, about harmonization, because 94% of the QCOs are based on of your ISO marks and IEC. That's what you can take back, because that's the harmonization which everyone is planning to do. So that those certifications work and you do not have to comply with QCOs. Okay?
Yeah, but you must factor that the cost differential and economic surplus which you can generate in India is far more attractive than you can do anywhere else. So if you are able to navigate with an efficient team, efficient support, I think despite perceiving all these barriers, a lot of things can be done. And especially with France, which has its own very strict labor laws and all. And for foreign companies, sometimes not an easy place to work with. But that gives also the French industry and professionals kind of understanding that you have to keep on working. Some things are there which you need to deal with. And that demands a process. So that's where India-France partnership is not just in terms of these FTAs and all. It is also this psyche, inbuilt psyche to work out difficult situations. So that is another binding glue. I think there's one more question. And it's the last question. Okay, I think we can have a chat on the sidelines. Thank you. Thanks to all the panelists.
Thank you to the panelists. And now we move on to our second panel on geostrategies around AI, data, and cross-border commerce. We will also have 25 minutes for this panel. May I request all the panelists to come on stage? I'll start by inviting Ms. Aparna Vishwanathan, advocate of Vishwanathan & Co., along with our other panelists, Alexandre Menet, Group General Counsel L'Oréal, Anne-Laure Wildou, Managing Director and Partner CMS France, Gonzague Despire, Chief Omnichannel and Data Officer of LVMH, Ms. Anan El Arak of INPI, and Mr. Ahmed Baladi, Partner Gibson Dunn, to do the context setting. May I please have your attention? Thank you. Over to you, Ahmed.
Mesdames et messieurs, bonjour et bienvenue à cette seconde session. J'avais prévu un discours en anglais, donc si vous me permettez, je vais switcher in English, if you don't mind. So it's a pleasure to open this second panel that looks at how AI, data, and cross-border trade are shaping power, innovation, business, and sovereignty around the world. We often describe AI as a technology, but it has moved beyond that. It is now a geostrategic infrastructure that will shape the balance of power and determine who succeeds in this new era. And the way AI is regulated today is shaping where innovation happens, where data flows, where companies invest, and how influence is exercised in the global economy. At the France Asia Foundation, young leaders from France and India have been working very hard on an AI white paper that addresses these issues. And we are very honored to have the opportunity to present the results of that white paper during the upcoming India AI Impact Summit in New Delhi next month. The analysis we conducted highlights different approaches followed by different regions around the world. In the EU, you're all aware of this EU AI Act, which was the first comprehensive horizontal framework for AI. It also raises some concerns about its complexity and its interplay with other EU digital regulations, and we hope that now the EU will fix that problem with a digital omnibus. Alongside this, India has emerged with a distinct model for AI governance. Instead of a single one-size-fits-all legislation, it is taking a policy-led development first part that puts adoption, scale, and ecosystem growth first. These differences are not merely technical, they are geopolitical. They shape how companies design AI systems, where models are trained, and how technologies are deployed across borders. For multiple multinational companies, this translates into growing problem of legal certainty and consistency. But against this backdrop, EU, India, and more particularly France-India cooperation stands out as a high-impact, forward-looking partnership with a scale and shared values to set global benchmarks. So where does this leave us? We are moving from debate about abstract regulatory models to very concrete operational questions. For governments, the issue is how concepts such as sovereignty, security, and trust are translated into procurement rules, assurance frameworks, and international cooperation. And for companies, the challenge is no longer whether to comply, but how to design systems, workflows, and data architectures. With that, the discussion of this panel will bring together voices from foreign policy, innovation, industry, data, and legal leadership to explore what works in practice. I'm now delighted to hand the floor to our moderator, Aparna, to guide us into that discussion. Thank you.
Okay, thank you very much, Amity. Good afternoon, everyone. I think we will do an abbreviated version of our panel because we have about 25 minutes just about, and we're also short a panelist. Welcome to Geostrategies around AI, data, and cross-border commerce. This is basically a conversation on how Gen AI and agentic AI powered by the cloud and the underlying data flows have been transformed into a question of national security and sovereignty. Just to give you a little bit of brief background without going into details, essentially what's happened is that recognizing that data infrastructure is actually a national resource which has to be protected by a geostrategy, in October 2025, the EU transformed its sovereignty concerns, which arose out of course, the US dominance of cloud computing and the cloud platforms, into the EU's Cloud Sovereignty Framework, CSF, okay? Along with something which is called Sovereignty Effectiveness Assurance Level, SEAL. So it's CSF and SEAL that you will hear us repeating a little bit during the panel. Okay, and the Cloud Security Framework turned what is basically was a political dialogue into solid metrics, which companies who are bidding for public contracts have to show that they meet these metrics that are designed to ensure both safety of the AI-enabled systems and protection of EU sovereignty. Now, the question which interests us is, one, how is this regulatory change going to impact operating models, and in particular, the operating models with the extraterritorial effect, namely the France-India business corridor. And what we're talking about are the GCCs, the Global Capability Centers, the AI-enabled BPO, the AI-enabled AI annotation, and the work done by the Indian IT majors, which is very significant. Their systems integration, their velocity engineering, their systems management. Okay, we wanted to ask the key questions that what's going to happen to this business corridor, France-India business corridor? What's happening in India, is it going to be limited to only looking at mass data or synthetic data? Are the GCCs only going to develop and not actually operate? Is the corridor going to survive this? Is it going to be resilient, or is it going to fragment? Now, with that, I'd just like to briefly introduce our very distinguished panelists. I'll start with I'll go in this order, with Mr. Gonzague de Pirey, who is the Chief Omnichannel and Data Officer of LVMH. He earlier worked at Saint-Gobain. He was CEO of La Paire Group and subsequently spearheaded K-Park, a French company. To my left is Hanan El Harak, who is the head of Networks and Data Processing Unit of the French Patents and Trademark Office, and she also leads the office internal AI task force. To my right is Anne-Laure Villedieu, who is the managing director and partner of CMS Francis Lefebvre. She's been a lawyer in the technology, media, and communications TMC sector for over 25 years, and she's also managing director of CMS Francis Lefebvre. Finally, last but not least, Mr. Alexander Menet, who is Group General Counsel, L'Oréal. His focus is on steering the group's global strategy through the intricacies of international law and transformative mergers. With that, I will start my questions. I'll have to shake it up a little bit because I'm missing my panelists, and I was going to start with French policy issues and questions regarding the French cloud. I think we'll start with Hanan. Because a very important question are the innovation flows across the France-India corridor. Now, from your perspective at the French Patent Office, where do you see the innovation workflows happening in this business corridor, and how do you feel that these new regulations are going to affect it?
Thank you for the question. I will answer from a patent view and innovation perspective. Patent filings do not reflect internal R&D organization, but they do provide insight into the types of technical contributions that are claimed and protected. From this perspective, AI-related inventions do not appear as a single linear pipeline. Rather, they cover different layers of technical solutions. Some focus on concrete products or industrial system, where AI is just one component amongst others, and some invention deal with improving the AI model itself, and in this case, AI model are considered as a mathematical method and are excluded from patentability. From a patent perspective, what matters is not where each task is performed, but who these contributions come together in a single inventive concept. This is where distributed teams raise practical patentability issues, can raise practical patentability issues. First is the inventorship. French and widely European law require human inventor. When teams are spread across the corridor, the key challenge is to clearly identify who made the decisive technical choice that led to the claim's invention, especially when AI tools are involved. This is less a legal issue than a question of internal governance. That can create difficulties later, particularly when several entities or jurisdictions are involved, and then that can lead us to the ownership. Inventorship and ownership are together can require clarity early on. And finally, sufficient disclosure. Distributed innovation can make patent drafting more complicated. When knowledge is fragmented, across teams, applicants must ensure that the final patent application remain coherent and enabling. Sufficient disclosure is one of the patentability criteria, and the person skilled in the arts, when read a patent application, he needs to fill out this patent application. So, for this question.
Okay, thank you very much, Hanan. I think I'll now move to my general counsel. Now, as the cloud security and sovereignty expectations arise in Europe, are we actually moving to a two-track model? Are we going to have one track for regulated sovereign workloads and another one for global scale? And if so, I mean, what's the decision now that CEOs have to make?
Thank you for the question, and I'm sorry because I have really an urgent meeting just after, so I will not be able to stay longer, so I really apologize. So to be able to answer to this question, yes, absolutely, we have to move that. But I think it's not really rocket science. If you see, I have a tech veterans experience, if I can say, right? But at the beginning of the cloud, the first solution of cloud, most of the providers were pushing a kind of hybrid mode in terms of cloud, between public and private. And in fact, why? Because at the beginning, we believe that most corporates will never go to Amazon or never go to public cloud and things like that. But finally, a lot of companies went to public clouds. And they realized, years after, despite what happened now in the world, that's probably, it's true that it's good to have some private solution, and at least where you can reinforce, if I can say, the security of our data. Most of corporates, put in the data lakes a lot of data. Most of them, they don't know what to do with their data. Or, they are facing now no longer data protection issues, but mostly who can access to those data. Who can access to the data, that's the first question. And after, of course, taking into account your data, the question will be, in fact, indeed, to have probably a two-track approach to make sure that important word, you can guarantee the robustness, in fact, of your data, but in the same time, the agility of your data. This is what, indeed, today that you have in terms of question. So what does it mean for a CEO? I'm not a CEO, but, for me, the right advice is firstly, of course, and we were mentioning that, in fact, your data, in particular for a company like L'Oréal, is like our product, safety, security of your data. It's major, right? The second point is, of course, to make sure that, and we see that more and more, and sorry for US corporation, but indeed to avoid to be totally locked in with super hyperscaler vendors and to find some other solution. And finally, how you protect, indeed, your invention. This is the main question for me. And in particular, the protection of your conversational exchange with the different agents that you can have. We know that, in particular, in many laws, there is a kind of lack, indeed, of legal regime, how we protect this, because in fact, this is really the informational patrimony of the company who is really clearly in charge, so we have to determine these type of things.
And okay, thank you for that. And what I'm wondering is, what's your view on all these the European cloud offerings by the hyperscalers? Is that going to be a solution or not something that's really going to work in Europe?
It's since many years we try to push European solution for that, and it never worked. No, but to be frank, it never worked. So is it now? And I think that's the point. It's probably the situation of the world today is going probably to force probably, all organizations, and in particular European organizations, to think differently. And we see that, but I must say that, if I could say, it's a personal opinion, but the fight is going to be complicated, and the challenge is going to be complicated. If you take an example with what happened with Mistral, it's a French solution and things like that. I don't know if it answers to all because I'm not an engineer, but the way French companies, the way the French government, the way our European, government could say, okay, let's focus on one solution rather than probably to use the other ones. I don't know. It's just an example, but I think it's going to be super complicated to push off one, cloud solution for Europe. We have probably no choice taking into account the situation today, but I'm not sure that, the debate will be there again. And we have been able, and I think it's an important message, in my view, that has been sent last week by the French president, that we need to take into account. In fact, our market, the European market today, is giving what? Certainty in terms of regulations. And I think there is a price for that. There is a price for that, and for a company, company hate instability. We want certainty in regulations. And it is true, and when you have a partner like India and Europe, and you can indeed deal on a solid and also permanent, at least regulation that are not going to change every day, I think there is a value for that. I hope that now European countries and European corporations are going to really to leverage that as a competitive advantage.
Thank you. And continuing with what's going to happen to the data flows in this new sovereign, highly regulated environment, let me go to Gonzague, who is heading Omnichannel, which is just a fascinating business. I mean, how they stitch together all the data so you're recognized wherever you go and they know what you're going to buy. It's like something I find fascinating. So can you tell me what's your view on what's going to happen?
What's going to happen, I don't know, honestly. I don't have a crystal ball, but thank you very much for the invitation. And maybe to start with one point of context. The relationship between India and the various LVMH maisons is a kind of a long-lasting story. Even long before the LVMH boutiques, there were some Indian Maharajas already. Traveling with Louis Vuitton trunks, already commissioning Bulgari to set the stones, or even choosing Christian Dior as a dress for modern India to be at the world stage. So I would like to say a long history continuing even in the last decades. With several important investments, like in 2013. With Moët&C investing in Chandon, India, in a state, important state in India, in the Make in India. You remember that program dating back 2013. And 2023, maybe you had the chance to visit the Louis Vuitton flagship store in Mumbai, or the big contract that we signed with what the president named before, with the Reliance Group, with Sephora, for the distribution, etc. So, quite a few important things there. Now, when it comes to technology, LVMH is not a technology company. So, yes, manipulating a lot of data, but we are not a technological company. We are not willing to sell technology, and we are not willing to become a technological company. LVMH is luxury industry. It's about human thing. It's about human creativity. It's about handcrafts. It's about selling in a store, etc., etc. So that's the visible part. But it's true that invisible, behind the scene, so much data, things, etc. So yes, we are taking this topic extremely seriously. Why? Because our business is fundamentally global. Our products, our brands are global. The products are manufactured in a given country, in a given atelier, by given craftsmen, and they are sold around the world. And that's duality between global business and local regulation, etc. Somehow we have to take it, extremely seriously. We would like to tackle this with a lot of pragmatism. When it comes to China, for instance, where the regulation is crazy constrained, with not even one customer data being able to go out of the country, a Chinese customer. But we were able to tackle it in the past years and to set in place a lot of specific system, isolated, etc., etc. We did it, and we managed to do it properly. So somehow, first answer is it's doable somehow, and we can find ways to run these global businesses, in the context of local regulation and local sovereignties. Not only one sovereignty, but sovereignties, which is obviously a challenge for a global business like ours. And I'd like to finish by saying that with these sovereignties, regulation, limit of transfer of data, etc., that impose us to do some specific investments, specific processes inside the company, I would like to say it's an opportunity to increase the resilience of our systems. A bit like was said before by my L'Oréal colleague, somehow we are forced, I would say, to decrease our dependency to the big corporate and big American suppliers, and somehow let's take the benefit from it is actually to improve the resilience. In this world, we believe it's critical for the long-term business perspective.
Thank you, Gonzague. And if I could just ask you in a little bit more detail, I mean, what about all the sharing of data that goes on? I mean, in the omni-channel, surely there is sharing. It's not just within the company. Surely it goes to the websites, the advertisers, the ad platform, the data brokers. I mean, how is all that going to work and across the Indian footprint?
I mean, this can work, with one very specific rule. The customer are giving us their data with their consent, and it's a kind of treasure, and we need to respect this treasure. It's fundamentally about the trust customers are placing in our brands. And the brand, for them, it's something which is so critical, so important, that we have to respect this very deeply, because what is at stake is a trust we have with the customer. So definitely we never ever share any personal data outside of the company. Even I would like to share something with you. You may not know, but LVMH is not one company, legally speaking. It's maison by maison. And even if one customer is giving his trust, his data, his consent to one maison, one brand, it's not shared with LVMH. So within LVMH, we are even not sharing the customer data, one maison to another. So we are, that's, I would say, absolute rule. We never share those data, and we run business like this, and I believe quite efficiently, though, despite this. So, that we say there's the overarching rule that are absolutely critically important, but still able to run the business.
Thank you, Gonzague. Now, last but not least, and I'm sure you won't mind being a connoisseur, Anlo, I wanted to ask you, okay, we are moving towards a two-track model. Now, can you give our audience a little bit of overview of what I meant when I said it's actually a metric? What are the companies going to have to show? I mean, it's no longer a legal doctrine, it's a metric. Can you unpack that for me? And then a little bit in the two-track model, how would you ensure that there's not going to be leakage between the tracks?
Sure, thank you. From my experience, when we advise multinational clients and they attempt to build a France-India two-track models, the failures are generally not caused by a single error. They generally arise from a fault line where legal assumption, operating pressure, and engineering reality collide. If I had to prioritize the risks for a CEO or for a general counsel, I would say that in a two-track model, misclassification is definitely the sin. Cross-track leakage is the visible failure, and loss of auditability is what kills you with regulator. What I mean is the root cause of failure is very often misclassification of the workload. Often the sensitivity of the data is misinterpreted or underestimated. The product teams may very often merely classify the data types without considering the use case, without asking themselves who is the customer, and without taking into account what's the future of the workload. For example, if you, in a POC, a proof of concept, you build a track for the data which are not regulated, and later you propose to a public authority, to a critical infrastructure operator or a regulated industry to use that track, then the entire pipeline is non-compliant.
Okay, and when you are structuring the two tracks for one of your clients, and part of the work is involving the Indian footprint, there's definitely going to be work done in India, then how are you going to structure that in terms of the data architecture, the processes, the evidence? I mean, what can they actually expect that they will do in India, and how is that different?
Generally, there will be an agreement in place, and it needs to be very concrete. It needs to be very operational, meaning that the scene that we see very, very often is the fact that the contract does not correspond exactly to the reality. Generally, the contractual clauses are discussed before the workloads are definitely decided, and that's the reason why you have so many risks that some data which are in the track of unregulated data may, of regulated data may pass to the regulated, to the unregulated track. And so the way you consider it is you really keep the control, the administration in Europe, and the track A data cannot be decided, the use of the track A data cannot be decided in India.
Okay, and I have, another question just to get the conversation going a little bit. Since we are in France, I'm very curious about the Clou de Confiance, the ANSSI cloud. Does that mean that France is really at a competitive advantage over the rest of Europe because you already have a sovereign cloud? Gonzague or Hanan? Anyone can...
the positioning of France versus the other countries in Europe, I think it's, again, for a global company like ours, we don't look at it, in this way, honestly. What is true is that for the cloud systems, today, most of the hyperscalers working with the big companies are American for, I would say, most of the world, except in China, where, obviously, we have to run on the Chinese cloud. So in our case, we are very keen to multi-cloud systems for the rest of the world, and specific one for China. Now, but all those hyperscalers today, to be able to run those global systems, are today mostly Americans, unfortunately.
And if I may add, I'm not absolutely sure that the protection of the French cloud, which is this famous norm Secnum cloud, is a competitive advantage, actually. I think most of the major companies are creating a company, the US ones, who cannot be sovereign under Secnum cloud. They create a company in Germany or in another EU country. They obtain the C5 certification. And honestly, from a competition standpoint, I'm not sure that Secnum cloud is really good to the French industry.
Okay, but are we likely to see another hybrid situation where the US hyperscalers, and maybe in tandem with the Indian IT majors, because they are pretty much tied to the hyperscalers, set up like a joint venture within the EU and then feed everything to that joint venture? I mean, this reminds me of 30 years of FDI work in India. I was like, it's going to be the same thing.
Yeah, I think this is what they are doing, actually. Yeah. It's quite clever, as on this side.
We're getting around that. But still, I think that the ultimate takeaway that I wanted, actually was hoping that we could give the audience, is that something about a trust pack. I mean, if you want to, create a trust pack that's the overlay across whatever system that you're building, isn't that ultimately the solution? And if it goes across the France-India corridor, then that corridor has a competitive advantage. What is your view?
Well, I think if you want to have a trust package, you really need to put in place a system where you treat classification as a board decision, not as an IT or a compliance task. You automate sovereignty boundaries. There should be no manual reinforcement and no exception without logs. You invest in evidence pipeline to make sure that you are able to prove that everything is logged, everything is versioned, everything is retrievable. You rehearse failure scenarios, and you align your contracts to workflow. This is the way you can build trust in a two-track model.
Anything you'd like to add?
Yes, I'm not a cloud specialist, but if I respond from a view of patent office, we deal with sensitive data, and the patent application are secret 18 months before publication, and we can't use other cloud, other French cloud. We need to use only French cloud for trust and for data sensitive.
Okay. Well, we are now out of time, but that really brings me to where I was trying to take the panel, that if we get trusted collaboration right, which is what Anne-Laure is saying, that we have the evidence, all the protections, whether it's the SOC 2 reports, the pen tests, what's auditable. It's not that, oh, I'll go catch an auditor and we'll figure out something, but no, it's audit ready right now. The regulator's asking me something right now, I've got the evidence, assuming I check the scope and in what point in time. So if that trust pack or the trusted collaboration is put in place, then it's possible that this operating corridor could make it more competitive in the new sovereign world. With that, I'd like to thank all my panelists and thank the audience.
Thank you.
Okay, so before we move to the cocktail, very important, we have our last panel of the day on from strategy to enforcement, strengthening India-France arbitration insights. We have about 25 minutes for the panel. And to start the panel, I would like to invite on stage Ms. Marion Coufiniel, member of the Paris Bar Council, along with her panelists, Mr. Nusrat Hassan, managing partner, Denton's Link Legal, Gal Lequier, partner, HFW, Thomas Clay, attorney at law, Paris Bar, Clay Arbitration and professor, Sorbonne Law School, Mr. Rajiv Sharma Fukir, partner, FTPA, and Mr. Nitesh Jain, partner, Tri-Legal. Can we have a huge round of applause to welcome our panelists?
Bonjour à toutes et tous. Pour cette dernière table ronde de la journée dédiée à l'arbitrage, je crois que nous avons surtout la mission principale qui est d'essayer de rattraper un peu le temps perdu. Donc on va entrer tout de suite dans le vif du sujet, en essayant de vous présenter une mise en perspective des pratiques d'arbitrage en Inde et en France dans un contexte où, dans chacun des deux pays, la réglementation est en train d'évoluer fortement. So we're going to start with Mr. Nusrat Hassan. Could you explain, well, what are the evolutions and the specificities and advantages of Indian arbitration framework, please? In a few words, of course.
Firstly, it's a pleasure to be here. Good evening, everybody. Let me, since we have just a few minutes, I'll try and summarize where we are in arbitration. So when I started my practice in 1993, I was faced with an Arbitration Act of 1940, which was primarily very court-centric. So arbitrations went on for years, sometimes decades. So it had completely failed. Fortunately, in 1996, we had a legislation which was called the Arbitration and Conciliation Act, which was also at the same time, UK, ironically, had also a legislation the same year. The 1996 Act was basically modeled under the UNCITRAL law. And as there are French lawyers here, you probably understand that it was based on primarily based on separation of agreement. It was based on the basis of autonomy. We had our Chief Justice speak about where we are now with reference to these aspects. Another thing which happened in post-1996 with Arbitration Act was there were several judgments which had taken place which further allowed court intervention. And again in 2015, we saw a large amendment taking place in the 1996 Act, Arbitration Act, which further emphasized party autonomy. It further brought in a section, which was one of the big challenges in India with regard to arbitration, and now it remains the only legislation in the world which prescribes a time limit insofar as in which the arbitration has to be completed, which now provides for 6 and 12 months. So 18 months you need to complete an arbitration, and an arbitrator has to pass an award. So today here we stand, where insofar as where you have provided a seat, like in India, which today expedites arbitration, where you can probably see an award within 24 months. And it's very common to see that. There are data to show that. In fact, the recent Queen's Mary 2025 survey shows that India has become one of the centers where you can rely on for your arbitration to be conducted. So I'll pause here for a minute. That may be something which is, but this requires a substantial amount of time to describe really how we have evolved over the last 25 years. But yeah, Marianne, over to you.
Thank you. Maybe we could go further with Nitesh Jain. Can you explain more about the recent amendments of the Arbitration Act?
Sure. Good afternoon, everyone. I had 10 insights, 10 points in relation to Indian Arbitration Act. Majority have been discussed by the Chief Justice. Balance Nusrat has done, right? So most of my job has already been sort of over, but let me try. Quickly, some of the important key decisions and developments in the Indian arbitration field. The topic is from strategy to enforcement. It's a very sort of broad topic. It involves various steps. Quickly talking about the drafting of arbitration clause. As we all know, it has various elements to it. Key issue is on the pre-arbitration step. In various jurisdictions, pre-arbitration is enforceable. In India, it's a mixed sort of situation. But the courts have largely said that the pre-arbitration is not enforceable. So therefore, you have to be very careful when you draft the arbitration clause. The Indian Supreme Court has said that the unilateral appointment of an arbitrator is invalid. So if a French company enters into an agreement with an Indian counterparty or Indian government, where they say, we will appoint the arbitrator or we'll have a panel of arbitrators, these are the names, that clause has been declared as invalid. India has done a lot of litigation around the concept of seat, venue, and place. Internationally, it's called a seat of arbitration. In the Indian Arbitration Act, it's called a place of arbitration. However, we all use venue for convenience, right? But this issue has now been resolved by the Indian the Supreme Court. They've said if venue is mentioned without any reference to seat, then venue is to be considered a seat. But I think any issue in relation to the arbitration clause can be resolved if you use an institutional arbitration rule. Just pick up the model law from the institutional arbitration rule. It will provide you for sort of all the essential elements. India is promoting institutional arbitration. You can have ICC rules seated in India. You can have LCIA. You can have SIAC. You can seat in India, outside India. So that's not an issue. Interim measure is something which is very key in relation to the Indian Arbitration Act. I've seen a lot of foreign parties using the interim relief measure as the worldwide freezing order. So the Indian courts have the ability to grant injunction even if the assets are not in India, because the injunction is granted against that party. So the Section 9 relief, which is the interim measure, is available even if the seat is of arbitration in India or outside India. You may not have the Indian law as the governing law. So there may be a dispute between a French party and Italian party. But there may be some assets in India. So either of the party can go to the Indian court and get relief. Indian courts have now recognized emergency order which are passed by arbitration seated in India. They are considered as order passed by the tribunal. Emergency orders outside India are not recognized, but there is an indirect way of recognizing it by filing for interim measures. Arbitration timeline, Nusrat has already spoken about. I want to emphasize on the expansion of the arbitrator pool in India now. It's no more the former judges. We have active arbitration practitioners. I have seen foreign lawyers coming and acting as an arbitrator. Indian courts, while appointing arbitrator, are appointing practitioners as arbitrator. I want to briefly touch upon the setting aside of domestic awards in India. The Indian Supreme Court recently came up with a judgment which says they have the power to modify. Internationally, it's been debated and it's been criticized, but that's not the case. You should read the judgment. What the Indian Supreme Court has said is, if the award can be severed between valid and invalid, invalid can be set aside if it deals with some issue which is sort of technical in nature. So instead of setting aside the entire award, you sever it and set aside the invalid to a limited extent. Enforcement of foreign award, the Chief Justice clarified that the Indian courts do not interfere in the enforcement of foreign award. Group of companies doctrine is something that we borrowed from the French jurisdiction from Dow Chemicals. English courts do not recognize this. Singapore, they don't recognize, but India does. There are criteria for it. Anti-suit arbitration is, anti-suit injunction is something which is developing in the Indian jurisdiction now. Indian courts, of course, the threshold is very, very high. They do not grant this for asking. But if the subject matter of arbitration, which is outside India, deals with provisions of the Indian statutory law, which is non-derogable, like the provisions of the Indian Companies Act, then the Indian courts may grant anti-suit. Just to conclude, Indian courts have become very, very pro-arbitration. It's very positive and sort of exciting environment for Indian practitioners. Various mistakes have been done, but Indian courts are sort of pretty fast to sort of rectify. The Indian legislature, as Nusrat also mentioned, we have had many amendments under the Indian Arbitration Act. There are still some amendments which are recommendation in nature. And so wherever we find some difficulty, government is very active in sort of identifying, discussing, following the international practices and incorporating in our legislature. So this is a quick summary of where we are.
Fantastic, Nitesh. I think just wanted to add one additional point to what Nitesh mentioned, is that foreign awards, which was largely a challenge previously, enforcing them in Indian courts, that has been, public policy was one of the grounds which was always taken up when we were opposing an award, which has now been narrowed down following a judgment of Renu Sagar. And this has made it very pro-enforcement. That has changed substantially the way foreign international business look at enforcement now in India. That has made a substantial change because, public policy was always considered an unruly horse. That aspect today is really, the Indian courts have done an extremely good job in narrowing that down.
Thank you, boss, Nusrat and Nitesh. Je vais maintenant donner la parole à Gaël Lequiec pour une mise en perspective avec la situation et la pratique parisienne, notamment peut-être avec un focus sur l'intérêt pour la protection des investissements étrangers et aussi en matière d'exécution des sentences arbitrales.
Merci beaucoup, Madame la modératrice. Je vais tenter d'être brève et pour reprendre le fil rouge de cette conférence, s'il y a bien un endroit où le legal rencontre le business, je pense que c'est dans l'arbitrage international et qui plus est à Paris. Je voudrais sur ce dernier panel revenir sur ce qu'on appelle le dernier kilomètre quand on parle d'investissement, de last mile. Favoriser les investissements internationaux et le commerce international passe par l'adoption de traités de protection réciproque et bilatéraux ou par la négociation de contrats complexes. Mais protéger les investissements internationaux et les échanges du commerce international passe par avoir pour les deux parties un système juridique stable, prévisible et moderne. C'est pour ça qu'il faut toujours prendre soin de bien négocier le mode de résolution des litiges qui est adapté. Et en l'occurrence, vous ne serez pas surpris, en l'occurrence, c'est l'arbitrage international qui s'applique le mieux pour résoudre les litiges du commerce international ou des investissements. C'est souvent et d'habitude le parent pauvre de la négociation. Vous savez, ce sont ces clauses qui tardent dans la nuit, lorsque le deal est closé, lorsque le risk sharing est fait entre les parties, lorsque les pénalités sont négociées. Eh bien, on en arrive des fois à 2 heures du matin en coupant la clim, à laisser les juristes se battre pour qui de la loi applicable, qui du mode de résolution des litiges. Et on sent tout de suite qu'il y a une tension dans la négociation de ces clauses, parce que naturellement, 2 parties qui sont étrangères ont vocation à vouloir avoir leur droit qui s'applique ou leur siège chez eux. D'expérience, s'il y a un critère à lâcher, et on peut en discuter, j'aurais tendance à vous dire, ne vous battez pas pour la loi applicable, mais battez-vous pour le siège. Le siège est essentiel puisqu'il va conditionner les voies de recours et les mesures d'exécution qui y sont attachées. Et vous allez me voir venir arriver à grands pas quand je vais vous dire que le meilleur siège que vous pouvez avoir en cas de blocage, optez pour un forum neutre, optez pour Paris, parce que Paris, c'est magique, il faut bien le dire, et ici, c'est Paris pour ceux qui ont la référence. Très brièvement, pour ne pas trop prendre votre temps et pour tenter de vous convaincre, mais je suis sûre que vous l'êtes déjà, Paris est vraiment la place de l'arbitrage international. On dit the home of international arbitration pour plusieurs facteurs qui sont cumulés. Le premier est historique. Il ne vous aura pas échappé que la Chambre de commerce internationale s'est établie à Paris en 1923. Si vous dire qu'à l'époque déjà, Paris avait un attrait et une appétence internationale pour la résolution des litiges. Depuis, Paris s'est développé. Il y a d'autres centres d'arbitrage, le CMAP, l'AFA, des chambres d'ailleurs très spécialisées après dans le maritime, dans les commodities, qui prouvent qu'il y a une attractivité. La CCI, qui est basée à Paris, a enregistré, si je parle de mémoire, en 2024, et pardonnez-moi pour les chiffres, 830 nouveaux cas, et ce qui fait qu'elle a un portefeuille actuel de 1800 cas ouverts, l'un étant d'ailleurs dans le top 15 des parties qui utilisent l'arbitrage international sous l'égide du CCI. Deuxième critère d'attractivité de Paris, c'est bien évidemment la qualité et l'excellence du vivier de ses praticiens. C'est des praticiens qui sont de diverses horizons. Nous avons des professeurs de droit émérites, le meilleur étant à côté de moi, des avocats. Nous avons également des magistrats avec un dialogue permanent. Et les acteurs, je parle sous ton contrôle Thomas, sont très impliqués et engagés dans des associations qui font vivre la place, qui la promeuvent, comme Paris Place de Droit, comme le Comité français de l'arbitrage, comme l'Association française d'arbitrage, qui font des travaux scientifiques, des colloques qui dépassent en fait l'hexagone national. Et qui fait qu'aussi cette place est très attractive. Deuxièmement, il y a l'international à Paris, on ne va pas le nier. Nombre de confrères ont été formés à l'étranger. Nombre de confrères exercent quotidiennement dans 2 langues. Nombre de confrères étrangers exercent à Paris pour faire de l'arbitrage international. Et nombre de cabinets internationaux se sont implantés depuis très longtemps à Paris. Le tout sous la bienveillance et l'égide du Barreau de Paris, qui a toujours veillé à promouvoir la place et l'arbitrage. Et il ne vous échappera pas que notre bâtonnier est un arbitragiste de renom également. 4e point, en France, vous pouvez vous appuyer sur des juridictions spécialisées de grande qualité. En 2018, la Cour d'appel a créé ce qui est la Chambre commerciale internationale, qui a une compétence pour résoudre les litiges concernant l'arbitrage international ou du commerce international. En 2024, elle a même une compétence nationale dévolue en matière d'arbitrage international. Elle connaît des recours en annulation et des appels contre les ordonnances ordonnant l'exécution de la sentence arbitrale. Le protocole qui est en place est très intéressant et assez unique à mon sens, sans faire de chauvinisme. Vous avez des magistrats qualifiés, formés à la matière. Vous pouvez plaider en anglais, vous pouvez faire entendre des témoins, des experts, vous pouvez les cross-examiner comme une procédure d'arbitrage et vous pouvez obtenir une copie en anglais de votre décision. Ce qui, à mon sens, est un point totalement pionnier et sur lequel Paris et la France, de manière plus généralement, et qui se multiplie à peu près dans d'autres forums. Avant-dernier point, la compétitivité de Paris en termes d'organisation d'arbitrage. On aime beaucoup Londres, mais je pense qu'à Paris, on peut faire un arbitrage international avec des coûts indirects qui sont bien inférieurs. Vous avez des centres d'audience qui sont de premier ordre, vous avez des sténotypistes, vous avez tout ce qui fait vivre Paris et des frais de conseil qui sont beaucoup moins chers qu'à Londres. Un LCI à Londres, c'est très joli, mais un CCI Paris, c'est ma foi beaucoup plus joli et beaucoup plus efficace. Et enfin, dernier point, et je passe la parole, j'ai été déjà trop longue, Paris est de toute façon une place qui est innovante et qui fait vivre le droit français de l'arbitrage. J'en veux pour preuve les gardes des Sceaux qui se sont succédés, qui ont décidé de donner la priorité à l'arbitrage international comme étant le droit au service de l'attractivité économique de la place de Paris. Et en ce sens, un groupe de travail a été créé en 2024 pour travailler sur un projet de réforme, pour vous montrer qu'en fait, le droit de l'arbitrage, il n'est pas statique, il est évolutif, il est moderne, et on est force de proposition. Ce groupe de travail a été co-dirigé par le professeur Thomas Clay, que nous avons la chance d'avoir, et la transition est donc toute trouvée, puisque vous allez avoir en primeur le calendrier, et non seulement la teneur de la réforme du droit français de l'arbitrage. Et monsieur le professeur Clay, je vous cède la parole.
Merci pour ce plaidoyer pour la place de Paris qui vient, elle ne l'a pas dit Gaëlle, qui vient de l'ancienne présidente de Paris Place d'Arbitrage, donc elle est quand même dans son rôle, mais pour autant elle est tout à fait convaincante dans les différents arguments qu'elle a développés avec beaucoup de pertinence et auxquels j'adhère totalement. J'en ajouterai un, c'est la qualité du droit français de l'arbitrage. La qualité du droit français de l'arbitrage interne et du droit français de l'arbitrage international, je crois qu'elle est reconnue unanimement, et cela depuis, au fond, les réformes de 1980 et 81, qui sont les réformes de codification du droit français de l'arbitrage dans le Code de procédure civile. En 2011, nous avons renouvelé à nouveau et réactualisé et modernisé le droit français, et puis la question s'est posée il y a maintenant 2 ans, en mars 2024, par le garde des Sceaux de l'époque, Éric Dupond-Moretti, de proposer une nouvelle modernisation, une nouvelle actualisation de ce droit français de l'arbitrage, tout en gardant ses grandes lignes et en gardant sa philosophie, qui d'ailleurs est assez différente de celle que vous avez exposée sur le droit indien, même s'il y a évidemment des points de connexion. Mais la question du siège est une question centrale. Peut-être qu'on aura le temps d'en discuter soit plus tard, soit dans le cocktail. Je ne peux pas malheureusement tout développer. Mais toujours est-il qu'il y a eu 3 gardes des Sceaux successifs. Alors nous sommes dans une période en France où il y a un renouvellement ministériel relativement récent, régulier, mais il y a, malgré les successions de ministres, il y a une espèce de ligne de force qui demeure dans cette instabilité politique, c'est la réforme du droit français de l'arbitrage. D'abord parce que le motif est porteur, mais aussi parce que c'est une réforme qui, pour l'essentiel, est réglementaire et n'a donc pas à passer par les fourches codines du Parlement, dont actuellement on ne sait pas très bien ce qu'il en sort par rapport à ce qu'il y entre. Et donc, le garde des Sceaux de 2024, Éric Dupond-Moretti, a annoncé la réforme. Le garde des Sceaux suivant, Didier Migaud, a installé un groupe de travail qui a représenté l'ensemble des acteurs de la place de Paris et que j'ai eu effectivement l'honneur de co-présider avec un magistrat, un haut magistrat, François Anselme. Il y avait dans le groupe de travail des représentants de chacune des associations, des think tanks de la place de Paris, que ce soit Paris Place d'Arbitrage, que ce soit le Comité français de l'arbitrage, que ce soit l'Association française d'arbitrage. Il y avait des magistrats, les magistrats qui sont en charge de l'application du droit français. Et puis il y avait également des universitaires, des représentants de la CCI et du CMAP. Bref, je crois que le groupe était représentatif. Et puis enfin, on a remis notre rapport en mars 2025 et ce rapport contient de nombreuses propositions, 40 propositions que je ne vais pas détailler. Je vais faire comme mon camarade, je vais me contenter non pas de les détailler, mais simplement de donner les 4 axes qu'il y a dans ce rapport en 2 minutes. Les 4 axes principaux de cette réforme, qui est une réforme qui poursuit la logique autonomiste de l'arbitrage international, mais qui va au fond plus loin dans cette logique et qui, je pense, propose d'aller au point d'aboutissement d'une évolution du droit français de l'arbitrage qui remonte, j'allais dire, à 1806, c'est-à-dire au Code de procédure civile napoléonien. On a eu le Code de 81, on a la réforme de 2011, et puis il faut aller au bout de la logique. Alors, 4 axes en 3 mots ou en 4 mots, en 1 minute. Le premier axe, c'est de créer un code de l'arbitrage autonome, parce qu'il est temps, parce que les dispositions relatives à l'arbitrage sont aujourd'hui disséminées dans 23 codes différents, donc on s'y perd complètement. Moi-même, j'ai découvert des codes dont j'ignorais jusqu'à l'existence à l'occasion de cette codification. Il y a des renvois avec des textes qui sont abrogés depuis des décennies. Enfin bref, il y a quand même là un magma législatif et réglementaire sur lequel il convient de toiletter. Donc un code de l'arbitrage, c'est plus utile, c'est beaucoup plus intelligible, ça donne l'accès à la règle à tout le monde. Et je dois dire que depuis que ce texte a été présenté, je suis invité dans le monde entier à faire des conférences sur le code de l'arbitrage. Donc en plus, c'est un argument marketing et que, évidemment, je suis prêt à soutenir, j'allais dire, hasta la muerte, jusqu'à la mort. Et d'ailleurs, la question s'est un peu posée, il était au printemps dernier. Ensuite, deuxième point, la disparition de la différence entre l'arbitrage interne et l'arbitrage international et l'absorption en réalité des règles de l'arbitrage international qui absorbent les règles de l'arbitrage interne. On est dans une époque, un monde où cette distinction n'a plus grand sens, sauf peut-être sur l'application de l'ordre public interne et international ou sur les questions de contentieux, de compétences dans le contentieux judiciaire. Mais l'arbitrage international français, c'est ce pourquoi il est connu. Il est temps qu'il absorbe les règles internes, dont beaucoup sont des résurgences, j'allais dire, de la Révolution française. Donc c'est un peu ancien. Troisième point, très rapidement, des principes directeurs de l'arbitrage, qui sont un peu les lignes de force, l'opinion, la conception française de l'arbitrage, qui seront au seuil du code de l'arbitrage pour guider aussi l'interprétation des normes relatives à l'arbitrage. Et puis, quatrième point, une augmentation, ou plus exactement une consécration du champ de l'arbitrabilité telle qu'elle existe aujourd'hui à des domaines qui, a priori, semblent réfractaires à l'arbitrage. Je pense en particulier au droit de la famille et au droit du travail, au droit de la consommation, mais en réalité, en droit positif, c'est déjà le cas, c'est déjà arbitrable, et personne ne le sait. Bon, donc autant le mettre dans le code et augmenter le champ de l'arbitrabilité pour procéder à une véritable évangélisation en France et au-delà sur le terrain, sur la terre de l'arbitrage.
Merci beaucoup. Pour conclure, Monsieur Rajiv Foukir, peut-être que vous pourriez partager votre expérience comparée justement sur l'efficacité de l'arbitrage et surtout vos réflexions pour son amélioration.
Yes, thank you, Marion. If you allow me, I will switch to English. I believe some of the audience is still English-speaking. And thinking of this audience at this late hour, I wanted to reassure you all that, with a few minutes at hand, I rather belong to the Henry VIII School of Public Speaking, who had 6 wives, remember, and to whom he said, "I shall not keep you long." I'm also the last panelist, it appears, or the penultimate panelist. And having heard my learned friends here, I'm wearing the bleu, blanc, rouge shirt, by the way, and want to share perhaps the French perspective. I know more or less what is expected of me, but I'm not so sure how to say it differently. Gaël rightly said, and I couldn't say it better, that Paris is not just one of the best seats, it is the best seat for arbitration. And I read with dismay in the Queen Mary Wyden case survey that we only rank second behind or below London. But Paris is better than London. Paris is better, is cheaper, and has better skill set. So, but just a few figures for you. Whilst Paris ranks in the top 5 of arbitration seats, my dear colleagues, in the Asia region, it is nowhere to be seen. And that doesn't just include China or other Asian states, it also includes India. So the question I put here today, and I don't have the answers, is why is Paris not in the top 5 or even first within the Asia region? And in particular, in the eyes of the Indian business community. But I have a dream, like one man said, that Paris will become the top seat, the preferred seat for our Indian friends, for the Indian business community. And it's not just about having the right skill set. We have that. It's not just about having the learned professors. We have the most learned here. It's not just about a modern system, which we already have. which speaks to everyone, the entire world. If you look at Indian exports, the latest figures of, let's say, end of 2024, out of 600 billion worth of Indian investment, euros, worldwide, investments to Americas, to Africa, and to the Middle East will roughly be 60% of that. All those underlying contracts contain dispute resolution clauses. And in those contracts, Paris should be the seat of arbitration. How do we get there? Is the question I put to you, my learned friends. We can market a code de l'arbitrage, certainly. I'm not sure it has been imported into the new decree, which seems to rather revisit the Code de procédure civile. We love codes in France. But looking beyond that, that is the reflection that I want to start today, that I want to suggest today. I'm not coming with answers, but this is probably the right forum to start that reflection and to nurture and promote exchanges between fellow practitioners, in-house counsel, to better understand the expectations of the Indian business community in France. I should add that India is not a country. India is a continent in itself. It is a mix of cultures. It is a mix of flavors. It is a mix of thought processes. One of the earlier panelists said there are very different ways of thinking. And for us practitioners, it should be that diversity that we should be able to fathom and translate into our ways of thinking. And likewise, we should be able to do that towards the French community. In other words, perhaps inside a culturally sensitive approach, looking beyond all the competence and the logistical side of things, which is extremely important. And that's what I dream to do. That's what I need you to help me achieve. And I think it is achievable. I believe that the president of the Bar Association said Paris is the city of love. Love relationships bring about disputes, but Paris is also the place where disputes can get resolved in the best possible way. So, vive la France, Jai Hind.
Thank you, Rajiv. Perhaps one word, just one word from Thomas Clé about...
Merci pour tout ce que vous avez dit sur la France et sur Paris. Et merci beaucoup. Juste un petit point de précision, parce que comme vous m'avez pressé, sinon oppressé tout à l'heure, j'ai oublié de citer le garde des Sceaux qui est actuellement en charge de la réforme. Et pourtant, Dieu sait qu'il est actif, Gérald Darmanin, qui depuis le début, depuis qu'il est en fonction, pousse la réforme du droit de l'arbitrage. Je le dis en présence de Max Brunner, qui travaille à son cabinet. Donc autant que ce soit que j'oublie pas ce genre que je commette pas ce genre de crime de lèse-république, si j'ose dire. Et Gérald Darmanin a rappelé encore la semaine dernière, lors des vœux du bâtonnier, à quel point il était attaché à la réforme et à quel point il ferait le code de l'arbitrage. Ça me permet de vous répondre, parce qu'effectivement, dans la chronologie, il y a un premier décret qui a été rendu public le 12 décembre, pardon, qui a été rendu public à la consultation jusqu'au 20 janvier. Cette consultation est terminée. Ce décret va partir au Conseil d'État dès qu'il sera terminé d'être rédigé. Ensuite, il y aura un deuxième décret et une loi. Et enfin, fin 2006, dans le calendrier, le Code de l'arbitrage 2026 devrait regrouper l'ensemble de ces dispositions. J'ai oublié de le préciser et il faut remercier le garde des Sceaux de porter à ce point ce projet. Merci.
Thank you all. Is there any question from the audience?
For me, just one observation. To make any jurisdiction welcome as a seat, the interference with the award should be minimized. That's what a client is expecting today. That's what. Sorry, I heard you in French, but I understood him in English. I can restart for you in English. Over coffee. So, in fact, we are amidst a matter in Supreme Court. Indian companies, international arbitration in those days. Seat is Paris. The other side, the losing side, challenges it in Indian High Court. Single judge says wrong court, get out. Appeal court says no. Supreme Court is taking up that matter. So, that was a live example of a ICC Paris seat.
I think Gail mentioned earlier that we have a very robust legal framework, a judiciary, that and a specialized division of the Court of Appeal. And I confirm that the current president is very competent, very well versed, Mr. Barlow, presiding judge, and that division is dedicated to dealing with arbitration-related disputes, post-arbitration, i.e. setting aside or annulment or enforcement issues.
Microphone.
I think there's a lot of example you can take from the Singapore International Arbitration Center. I think that a lot of awareness needs to be created for what you mentioned, Rajiv. If you want the disputes to be resolved, especially the data shows that there's about $12 billion which have been invested in the last decade between Indian and French companies. So there are disputes will need to be resolved. And in that case, SIC is a great example to see how they managed to attract the Indian disputes to Singapore.
Thank you all.
Thank you so much, our panelists. Please don't leave. We just have 5 more minutes left before we officially close the program. And may I invite for the closing remarks Ms. Anne Desmond from Business France, who's Head of Geographic and Strategic Events. Thank you.
Good evening, everyone. I'll be brief. Thank you very much, Yvki. It was a pleasure to be here today and to see this wonderful Indo-French Legal and Business Conference. So as we close this afternoon of very insightful discussion, I will just very briefly highlight the role of Business France and also speak about the momentum that is currently shaping our bilateral relationship. So Business France mission is quite clear. Our role is really to support the international development of French companies abroad and also to attract foreign direct investment into France. So we have offices all over the world. We are a public organization. And in India, we are, I would say, directly in bed, at French embassy in Delhi, but also at the French consulate in Mumbai, Bangalore, and also we have an office in Chennai. In India, our teams work every day basically to help French businesses navigate a fast-moving market, understand regulatory frameworks with partners, and also we are supporting French companies to build strong industrial and technological partnerships. We are also supporting Indian investors looking to establish or to expand their activities in France, offering, tailored guidance to have access to our national and regional networks. This mission is now taking a new significance with the FTA happening. So this agreement will clearly strengthen legal certainty, it will reduce obstacles, and it will also create a more predictable and attractive environment, as we said before, for companies on both sides. It marks also a major step forward and represents a unique opportunity to deepen and accelerate Indo-French cooperation. So to build on this momentum, I would like to invite you to an event which is called Ambition India. It's an event that we have been organizing several years. It's the 5th edition. The last edition was at the French Senate, so we will do this event on the 28th of April at the headquarters of Business France. This event is designed as a practical platform with high-level discussions on bilateral priorities, but also with sectoral roundtables, networking, and also B2B meeting that will be happening between French companies, but also Indian delegations. So this year, clearly, with the FTA coming into force, the forum will be particularly strategic on both legal and business communities. On a personal note, I had the privilege of working 5 years in India, in Mumbai, and those years helped me shape my understanding of the country's extraordinary dynamism and of the immense potential that is happening and the potential of collaboration between our two countries. So I'm concluding this session today. I would like to thank you, and I would like obviously to invite all to this event that will be happening on the 28th of April, and we look forward to welcoming you and supporting more Indo-French ambitions. Thank you very much, and thank you.
Thank you, Anne. And now to conclude the session, I would like to invite back on stage Mr. Prashant Kumar, President of the Bar Association of India, for the vote of thanks.
Thank you. I think it has been a wonderful afternoon with the inaugural session setting the stage. And it could not have been done. So much has been discussed today in such a short time frame, thanks to all the background preparation done by Indo-French Chamber of Commerce and Paris Bar Association. The Bar Association of India was privileged to put the relationship in place. We had Paris Bar in New Delhi in August last year, represented by Vanessa and Mariam, in what we organized Rule of Law, International Rule of Law Convention on economic governance, principles of rule of law and global economic governance. So that is where this idea of this event was discussed by Vanessa and Mariam with the chamber, and here we have a wonderful event. I thank each of the panelists who have, in a very short time, being able to present their ideas. I think each of the topics requires a conference of its own, but still we were able to compress it. And in this afternoon, we have quite a good number of audience still present. So I won't like to take any longer, but just to express that this is one of the first events. And I think through this collaboration, we will have many more. And as in the last session, that Paris is a better place than London to do arbitration, I fully endorse it. But at the same time, we have to spread awareness, not only what is available here, but also, you know, there is a lot of apprehension on the cost and other aspects in India, that they think Paris is a city of luxury. So your brands are your ambassadors, but they also create a picture of luxury and cost, which is to be dispelled. So we have to find ways how to dispel that. And in April, Bar Association of India is discussing legal reforms in India with participation of Indian policy community, where we are trying to bring in a very important aspect, which will bring arbitration and relationship with European countries closer. That is to bring in the concept of good faith in Indian contract law, which is missing because, all other jurisdictions which follow common law, like United States, Canada and all, which have manufacturing bases, not just trading countries, have evolved their law and brought in good faith. And that's where, there is a mismatch of expectations in terms of legal culture. If we are able to bridge that, then, working together will be much more rewarding, fruitful, and we'll be able to put legal foundation for long-term relationships, which these investments require. So that is one aspect. And secondly, we will work with Paris Bar to see how we can promote exchanges of legal professionals, how we can have training, how we can promote arbitration and dispute resolution, and also for ICC arbitration, for SMEs, where cost of travel to Paris and all is quite high for certain level of disputes. We can work on that, how to bring those costs down, apart from the institutional cost. What part can be done in India in terms of availability of infrastructure? So Bar Association of India in New Delhi has full infrastructure today, where you don't need to go to a 5-star hotel to conduct arbitration, and fully supported by IT framework and all. So I think we need to have these institutional collaborations in which we can give further comfort to the parties to do dispute resolution at a lower cost than, a prolonged arbitration having costs of hotels, other things and all, whereas the project is located in India like that. So these are the things which I think we can work on further. This is a very good beginning, and we should continue with it. And the Bar Association of India is going to support it fully. And we are committed to facilitate this arrangement. And lastly, I'll just point out, Chief Justice spoke about bilateral arbitration. We are finalizing bilateral protocols with German Federal Bar, with German Chamber of Commerce. They were in Chennai in December, where we worked on it, and we are taking this idea forward. And we love to work with our French counterparts to do the similar thing. Thank you.
Thank you, Mr. Kumar, and thank you to all our participants, speakers, and sponsors. I now invite you to the bar, off the bar, at the 3rd floor. Thank you.